Good morning, everybody, and welcome to the County Commissioners meeting for the 12th of July. Would you all please rise for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, first thing we have on our agenda are the minutes. Gentlemen, do you have any additions or corrections?
I do not.
I do not.
Okay.
I move to approve the proceedings of the Board of County Commissioners, Montezuma County, as presented for Tuesday, July 5th, 2022, as presented.
Second.
Okay, it's been moved and seconded to accept the proceedings of the Board of County Commissioners, Montezuma County, July 5th, 2022. Any further discussion? All those in favor?
Aye.
Aye. Okay, and 9 o'clock, planning.
Good morning.
Good morning. So we have a public hearing, first of all. So, okay with that, would you call the roll, Kim?
Commissioner Candelaria,
Here?
Commissioner Lindsay,
Here.
Commissioner Copenhaver,
Here.
Attorney McLaren,
Here.
and Kim Purcell, Montezuma County Clerk and Recorder. Notice is hereby given that the Montezuma County Board of County Commissioners will hold a public hearing for review and a proposed after-the-fact high-impact and special use permit application and commercial planned unit development application submitted by Stanley Investments LLC, agent Blaine Bowers, on property located at 6572 Road 24, number 1 through 5, Cortez, Colorado, consisting of 2.27 acres, more or less, located south of Road G, east of Highway 491, situated in Section 10, Township 35 North, Range 16 West, N.M.P.M. The hearing will be held Tuesday, July 12, 2022 at 9 a.m. in the Commissioners' Hearing Room, Montezuma County Administrative Offices, 109 West Main, Cortez, Colorado. Interested persons may attend and give input. Information may be obtained from the Planning Office, from the Planning Office online services at https://co-montezuma-co.smartgovcommunity.com public home. You may also contact the Planning Department at 970-565-2801 with questions. Dated this 14th day of June, 2022, Kim Purcell, Clerk, Board of County Commissioners, Montezuma County, Colorado, published in the Journal on Wednesday, June 22nd, 2022.
Okay, thank you, Kim. All right, Don?
Good morning. Blaine Bowers is here. He's the contractor and the agent for Stanley Investments. So this is down south of town, south of G and 491. There was an existing 5-unit apartment complex from, I don't know when, 70s, 80s on this property. They last year built a new 6-unit apartment complex. Unfortunately, they didn't contact the planning department. They did get a septic permit. They did get electrical plumbing permits through the state. We contacted Stanley Investments and then Blaine, just to let them know that they needed to go through our planning office. So that's why we're doing the commercial planned unit development, high impact permit, special use permit for the property. It's slightly under 3 acres, but with the high impact permit that allows for that zoning and that commercial planned unit development designation. That's basically it. Everything is in and in place, and the septic system's in and been permitted. I believe that's an existing access off of 24, but I think Rob wants to go ahead and permit it just so that it's given a number and we have that on file. But it's the same access permit for the original existing complex.
You want to add anything, Blaine?
No, basically, Jim, what I did is I just approached it as I've done all my jobs in the county. Had no idea that we had to do the high impact or anything like that. We had an existing address, an existing entrance to the existing fiveplex down there. So basically, Don educated me on what needed to be done, and so we took all the formalities and everything. I did meet with Cap Allen down there, though, in regards to the septic system and whatnot, because Gary had possibly thought about coming in on 24.2, and we got to talking, though, and Cap even said that we'd probably have to get the county involved as far as the new access and so on and so forth, so Gary just decided to leave and go with the remaining access. And so it was basically just a...
So basically, everything is coming off of 24 instead of 24.2. Everything is as it
Correct.
currently existed previously.
Right.
Everything is coming off of there, and the septic systems are all permitted, so they're all adequate for the complex.
Right. Yeah.
So here again this week, we're listening to the same thing. You know, we're how do we educate? And I'm going to ask you too, Blaine, because we're struggling with this. Everybody just thinks that they can actually just proceed, and I'm not.
Yeah.
But how do we get the message out that there actually is a land use code that you do need to comply with prior? You know, this issue came up last week, and it's always an after the fact, which obviously this complies, the setbacks are good. I mean, looking at it, it's not anything like that, but you don't have to answer me now, but
Yeah.
just think about it. What does it take to get people to understand that the land use code still has to be complied with, and we have to make sure that it's fair to everybody and equal how this is getting put out there. So again, you don't have to answer that right now. Think about it.
Sure.
You can email us all or whatever, but we've got to figure out how to educate our people and to let them know that it's not just
Yeah, just jump in and do it.
yeah, just jump in and do it. You know,
And-
there is compliance with it.
Exactly, and basically, you know, I take full responsibility, because Gary, Stanley Investments even asked me as their contractor, you know, what are the formalities, you know, and basically, you know, I'm just gonna say it out of my own ignorance, you know, I just approached it like I would any of my other projects in the county. You know, we had an existing access, and we had an existing address, and we were basically just adding, you know, never once, and to be honest with you, Jim, this is the first time I've ever done an apartment complex versus a residential home.
Right.
So I was unaware of all the formalities. So, and so, but basically, yeah, I've got everybody else involved, Empire, Atmos Energy, you know, every, Cap Allen with all the engineer and design for the septic and everything, just as I would any other job, you know, but just did not understand all the formalities as far as the high impact and.
From commercial to residential.
Exactly, yeah.
So maybe that's the key, is that, you know, if you're doing something commercial, make sure that it's definitely, it is a different creature from residential to commercial.
Sure.
So anyway, that's all I have right now, Commissioner.
Just for everybody in YouTube land, if you're building a residence, you still have to contact planning. It doesn't matter what you're building. If it's a residence, if it's commercial, residential, because road impact fees apply.
Setbacks apply.
Setbacks.
Setbacks are a big thing.
Septic system,
Septic systems. So,
access, driveway permits, so anything that's gonna be built, other than maybe a barn that's got no utilities or a shed, as long as they meet the setback requirements, they need to contact planning. They need to go to our online permit center, they need to get entered into the system for any type of development.
And normally, like, and like out in the county, obviously, the planning is contacted, obviously, when we pull a septic permit, you know, and that's when that's all taken care of, so that's just kind of the same basis I was following, so. But we knew we'd have road impact fees, we knew, we'd have septic permit fees and all that stuff, and so on and so forth. So, but as far as all the other formalities, completely unaware of, so.
Okay.
Don, are you seeing any significant adverse impacts to the neighboring properties for any reason because of this?
Not on this particular application, no.
Okay.
There was one comment, if and when Montezuma Water District 1 ever gets their main water supply upgraded, they probably will request an upgraded water tap for this, but currently, the supply isn't there, so that condition exists. But, as far as any other impact, we don't see any.
And all the utilities are good?
Yes.
Okay.
Yeah, from everything that I read on here, everything is up to speed. It just didn't go through the process.
Correct.
Okay.
And unfortunately, the previous septic environmental health person, this went through with CAP and didn't get addressed, didn't get sent to planning, just, so that's why this is delayed so
Okay.
much.
All right.
But I
Okay,
think that's
anything
rectified
else?
now.
Right now? Okay. All right. Commissioners,
I
any
have
questions
no-
before I open
you asked
this
my
up?
question about
The
education
septic for
ability.
the old apartments?
Yes, there is a permitted existing septic system that's individual from this new system.
Okay. Well, then I will go ahead and open this up for public comment. Anybody wishing to speak for or against this application, please come forward to the podium, state your name and address for the record, and you may address the board. Okay, seeing no public comment, I'll close the public comment session of this hearing, and we will bring it back to the commissioner. Do you have any other questions for planning and/or the
No.
applicant?
Just, I mean, outside of this, my concerns is we keep doing these after the facts, PUDs, and if nothing else, this may be leading us down the road to building permits if we're not careful.
I think it's, I think the education component is why I asked you, is like, how do we make everybody aware? Because this land use code has been in effect since Commissioner Lindsay put it in
24 years.
98 or something like that. So, it's commercial and residential are two different creatures, but as Don stated, you still need to at least check with planning to make sure that, we're complying with the setbacks, septic, road impact, I mean, so on and so forth. So, hopefully, people that are listening, there are things that we do have to comply with to keep it equal to everybody. Which, like I said, you don't have to answer that now, but think about it, and if you come up with something creative to try and help us educate the rest of the people, it would be appreciated. All right, gentlemen, if you have no other questions, then we have a decision to make here.
And Don, real quick, what did planning and zoning say about this?
They were unanimous to recommend it for approval.
Okay.
Only condition was if and when Montezuma Water requested the upgraded tap, that they accommodate that.
Thanks.
And we spoke with Blue Door down there as far as the water tap was concerned, and they didn't have, basically what they told us to do is tap into the main line that's feeding the other 5 right now. We had sufficient water supply, but I guess there's a possible new truck stop or Love's or something like that going in down there where the M&M used to be, and they said the infrastructure would be changed at that point, possibly, and then new upgraded water lines would be put in at that time to service all that area down there. And at that time, they would approach Stanley Investments for their new water tap.
Gotcha.
So
That's
that money was just basically
down the road.
Yeah, basically just set aside. So.
Okay. All right, gentlemen.
I would so move we accept the proposed after-the-fact high-impact and special use permit application and commercial plan unit development application submitted by Stanley Investments LLC, located at 6572 Road 24, numbers 1 through 5, Cortez.
Second.
Okay, it's been moved and seconded to accept the proposed after-the-fact high-impact and special use permit application and commercial planned unit development application submitted by Stanley Investments LLC, agent Blaine Bowers, on property located at 6572 Road 24, number 1 through 5. Any further discussion? All those in favor?
Aye.
Aye.
Aye. Okay, and I will close this public hearing.
And Commissioners, I have a conflict with this next one, so I'm going to step out, and Attorney John Baxter is going to fill in for this hearing.
Okay. Could you catch that door, Shane?
Pardon me?
Catch that door, please. Okay, we are past 9:10, so we have another public hearing. Kim, would you go ahead and call the roll?
Commissioner Candelaria.
Here.
Commissioner Lindsey.
Here.
Commissioner Copenhaver.
Here.
Attorney Baxter.
Here.
Kim Purcell, Montezuma County Clerk and Recorder. Notice is hereby given that the Montezuma County Board of County Commissioners will hold a public hearing for review and determination of a proposed general planned unit development and rezoning application submitted by Edward and Bette Lewis on property located at 13301 Road 35.9, Mancos, Colorado, consisting of 13.54 acres, more or less, located south of Highway 184, west of Road 35.9, situated in Section 4, Township 36 North, Range 14 West, N.M.P.M. The hearing will be held Tuesday, July 5th, 2022 at 9:10 a.m. in the Commissioners' Hearing Room, Montezuma County Administrative Offices, 109 West Main, Cortez, Colorado. Interested persons may attend and give input. Information may be obtained from the Planning Office, online services at https://co-montezuma-co.smartgovcommunity.com, public home. You may also contact the Planning Department at 970-565-2801 with questions. Dated this 14th day of June, 2022, Kim Purcell, Clerk, Board of County Commissioners, Montezuma County, Colorado, published in the Journal on Wednesday, June 22nd, 2022.
Okay, thank you, Kim. The applicants? Okay, good morning.
So the Lewises have their property there on Road 35-9, south of Summit Reservoir. They have currently their residence and another mobile home residence along 35.9. And prior to this, at the southeast corner, there was an old mobile home there. It was removed a few years ago. And so currently, they're looking to, or we're looking to install a new mobile home for their son to reside in. We informed them to get an address that they would have to do a PUD application in order to have 3 residences on the single parcel. During that process, the mobile home was en route to deliver, and they had no place to put it, so we informed them that they could use their house address to get it delivered to the property, but not to set it on a foundation or connect it. The week prior to the P&Z meeting, unfortunately, the delivery people set it on the foundation, and the Lewises also installed a septic system without an engineered design or a permit. So it's currently in place at the location shown there on the map. In reviewing all this with planning and zoning, It also came up that there's a question on the deeds, and the other item is the covenants for Summit Lake West Unit 2. Unit 2 does not have recorded covenants. Unit 1 does have recorded covenants that restricts having 3 residences on one parcel. There's some other language concerning mobile homes, not having mobile homes, manufactured homes. So at that point, with those legal questions and with the fact that they set the trailer when they weren't supposed to, P&Z recommended to deny the application, mainly because of the legality questions on what and how that impacts the county's decision with the land use code regarding deeds. So since that meeting, the Lewises petitioned to have a public hearing before the Board of County Commissioners, which is what we're here for today.
Okay. Give you opportunity to also address the board.
Yeah, and if, Betty, if you would, you may want to just kind of describe your first mobile, the second mobile, when the house was built, just for a little background.
When we moved in 87, there was a trailer house there at that time. They, we lived in that until approximately 2000, maybe 2001. And at that time we built our house. The second mobile home, whenever my son was out of school, he bought a trailer house. He put it in there. That was approximately in '94. It was shortly after he graduated from high school. He bought him a trailer house. He put it in there. And how long did you say he lived there?
2-3 years.
And then when did you buy the other trailer? Was it about that time?
Somewhere around 2007, I remember.
Anyway, he lived there for a few years, and he pulled that trailer house in, and right behind it, we brought another one in, and it's still there today. There was also another trailer house brought in approximately 2003, maybe 2004, and it was there until my son demolished it and got it out of the way and leveled it up and got it all looking good so he could put his trailer house in. And also on the property tax, it does show 3 addresses. The driveway permit, I talked to the Road and Bridge, and they looked it up on their map showing that there was an existing driveway. So there's access to all 3 locations. When Wade started to bring in, or made arrangements to bring in the trailer, he checked with the water company to see about getting a water tap, and it was too much. He couldn't afford it right now, so he went ahead and put in a septic, or a cistern, and he also put in the line so that he could get a water tap when he could afford it. And the septic, it is put in. He does that on his job, and he said that as soon as this was all approved, that he could get CAP to come and inspect it. There's no problem there. But we are waiting on all of this right now before we're paying any more to these people, because we don't want to just throw our money away.
We got a permit, it'll be paid, if it's approved, it'll be paid and done today, so. And I'll get Cap to engineer it and inspect it and make sure it's all his, so.
So the septic system is put in prior to the engineering?
It was a temporary septic system for my camper when I was just living out of my camper with the intentions of expanding it once I figured out my house situation. But in my ignorance, I didn't permit it before I put in just a temporary one. I figured I'd do it once when it was done, so.
Okay.
But like you said in the last one, a lot of this is kind of that same boat of what you were talking about earlier, about after the fact, which is a lot of my fault and my communication with the house people too, so.
Okay.
I was pretty eager on this. I didn't know we had to go through all these steps to do all this stuff. I don't know where to start with, it was a whole new story.
Especially since there was a trailer house there to start with.
So the residence, the mobile home in question is obviously the one where the arrow is at. So that was removed,
Yes,
and now we have a new mobile home, or a different mobile home in that
it's
place.
not right at that location, but in that area.
Mhm. So we have 3 others also on there, you stated, so you have the house, and then you have 2 other mobiles on there?
No, there's only three mobile home, or 3
Three,
residences.
3 total, so 2 mobiles, 1 house.
And on the property tax, it shows 3 locations.
Okay, so unit 2, that has no covenants, and unit 1 that has the covenants, the restrictions, what unit is this?
This is in Unit 2.
Okay, so unit 2.
You mentioned something about a deed restriction
Correct.
as to,
Attorney Baxter's gonna have to, give his inside input on that.
So basically, I believe that Unit 1 has these covenants, not Unit 2. But the deeds in Unit 2 incorporate the covenants just into the deeds, and they basically have the same restrictions in them, from what I can tell. This is a little odd. I don't know how this happened, but when the packet that I was provided had the first deed, probably when Summit Lake West was created, dated back in the 70s, 76, and it says that the deed is subject to the following protective conveyance agreed to by second parties. Said property shall be used for one-family residences only, and no trailer home shall be allowed on the property as permanent residence. And then it excludes certain things, double wides, modular homes, lands. Land shall not be used for manufacturing or industrial purposes. So basically, that, to me, that's a little ambiguous. And as you guys probably know already, it's not really your job to enforce covenants. This is language from a covenant. It's really the primary responsibility falls on the landowners that are all part of the same neighborhood. So what I found a little strange is in the next warranty deed, somehow that word "no trailer homes shall be allowed on the property," they left out the word "no." And it says, "and trailer homes shall be allowed on the property." And so that's, I think, an obvious oversight and misprint, unless somebody was purposely trying to change what was allowed on the property, which they're not allowed to do. So I think how you all should approach this is only to understand that there are covenant restrictions on the neighborhood, on the Unit 1. Inside the deeds say that they should only have probably one other residence on the land. They probably can be interpreted differently. I mean, they could figure this out in court if they want to, but the main concern for you all should probably be, what are the adverse impacts to the neighbors? If people are violating covenants or violating their deeds. You don't enforce those, but if there's adverse impacts to the neighbors, then certainly you can and maybe should consider them. So I wouldn't get too in the weeds. I sounded like I did get too in the weeds, but I wouldn't get too in the weeds about the covenants, the deeds, those types of things. Are they in violation? Maybe. It looks like they might be, but it's only consideration, not binding on you all. I think probably what's more important is P&Z's recommendation, what neighbors have to say. You know, I think that I had heard from planning that there was a letter or two. I have not seen anything that was submitted from the public, and if we have those, do you all have them in your packet?
I think Kim has.
Okay.
Kim has one.
So we should make those part of the record as well.
Just a quick verification, did he introduce himself, or did we introduce him?
Just stand fast, sir. This is our attorney right now, and this is our discussion. I'll open it up here in just a little while for the public, but right now, this is our discussion, okay? So this is our attorney.
And
who
I'm
is
John Baxter, and
filling in.
I should have maybe, sorry, because I did just start talking. And so yes, I'm an attorney just covering this particular situation, advising the commissioners. It's my only role, so my client here are these three guys.
So,
I think it needs to be put into the record, whatever the letters are. Either we could just include them, or I think better for the public hearing, a better procedure would be to read them in. Are they super long?
I think we can read them as soon as I open up the public comment. I'll give you the first shot at it. Kim, this is still within us as this discussion, and that's how I want to keep it, so that we don't lose track of what we're doing. So commissioners, do you have any other questions before I open this up to a public hearing?
I have a couple comments too, before the commissioners go, if that's okay.
Mm-hmm.
There has to be engineered septic, period,
Yep.
if this thing's going to get approved. If you guys are gonna go against planning and zoning, there would have to be a condition that there be engineered septic, before you could do that. And the water source, that I think was a concern. I don't know what kind of verification there is, but you know, if they'd allow planning to verify that, or if there's some sort of evidence, but there needs to be a water source as well. You know, they can use a cistern if they want to, but you just have to verify that there's a water source and it's not adversely affecting the neighbors drawing from their water source.
Correct, and I think that all is spelled out in the land use code also. It has to be a patent water source, correct?
Correct.
So, yeah, obviously there's some issues right there that we don't have water and we don't have a septic system that's actually engineered or designed yet. So with that, I'll go ahead and.
We do have the paperwork from the water people that as soon as it just does get passed and not dealing with the cistern no more, I'll put the tap in, have it done with them. We got the paperwork. And we have the septic permit right here. We'll fill it out, I'll turn it in when we leave, if we get to that point today. And I got Cap now, and I deal with him 3 or 4 times a year putting in septic systems, so I'll have him do all his side and have a full permitted septic deal. And we have to put it in the, whatever you call it, stipulations part of it, or we can't, but that will be done, so.
All right.
We received a letter from Montezuma Water as well, that water is available.
Okay, so water is available, and the septic system can obviously be designed. So commissioners, do you have anything else?
No, right now.
Any questions right now? Okay, well then, I will open this application up for public comment. Anybody wishing to speak for or against this application, come forward to the podium. You may please give us your name and address for the record, and you may address the board. But before you all go, just hang tight, because I want to give the clerk the opportunity to read the two letters that we have, and then I'll get to you.
I only have one.
Oh, okay, one.
So I believe there was another one that came, but it didn't come to me. So This is from Pam Chipman regarding the general plan unit development and rezoning application submitted by Edward and Bette Lewis on property located at 13301 Road 35.9 Mancos. The following are my comments regarding this property. I am writing to comment on the public hearing on application submitted by Edward and Bette Lewis on property located at 13301 Road 35.9 Mancos, Colorado. This particular property had already been subdivided at least a couple of times prior to them purchasing this property. This has taken the original 40 acres and become 4 smaller acreages of 6 acres, 7.1, 11.2, and theirs at 13.5 acres. They have already installed a single wide trailer several years ago without any input by the neighbors in this section of Summit Lake West. Now they want to add another home on their acreage, and as of this date, have done so. This is complete violation to the original intent of the developer of this subdivision. It is clear that the intent was for this portion of Summit Lake West Unit 2 is for the acreage to be 40 acres. Lewis property, whether officially subdivided or not, is functionally subdivided into 3 households on 13.5 acres. Their deed, as most of ours in this unit, has a protective covenant which states said conveyance subject to the following protective covenants agreed to by second parties. Said property shall be used for 1 family residence only, and no trailer homes shall be allowed on the property as permanent residence, except for double wide and modular homes. And said land shall not be used for manufacturing or industrial purposes. Since our deed is a legal document and the covenant applies to the property itself, their limitations are legally binding for anybody, just as the legal description of our properties. So how would the county commissioners allow this to happen with this in place? It is a dangerous precedent for the rest of us who purchased with the assurance of this legal document. I oppose this from happening. It increases the density of population and traffic in this section of the subdivision, which was not the intent of the original planning of this area. Please reconsider this and support instead the protective covenant. Thank you for Thank you for your consideration. Pam Chipman, 36320 Road N, Mancos, Colorado.
Okay, thank you, Kim, and that's the only one you have?
That's the only one that I
Okay.
have.
So we got that into the
Yeah.
record. That's the same one that,
That's the same one I have.
so, okay,
Thank you.
now you may step forward. Thank you for waiting.
Hello, my name is Don Harwood. I live at 13296 Road 35.6. And what my wife just handed you, 2 things. One is a map that shows the Lewis property, which is in yellow, surrounded by the other property owners within about a mile. And those highlighted in pink are ones that are opposed to this development change. The other section shows another aerial photo of the Lewis's property, and it shows where listed existing buildings are and where people are living as of this time. So what I want to get to, the County Planning and Zoning Board had a dilemma in their May 12th meeting of what to do with the Lewis's application for the rezoning of the 13-acre unit. They did not approve it, but they passed the information with the contingencies along to the county commissions. It appears to me that the Lewis's went ahead with site work. They put in a pad, septic, utilities, etc., then ordered up and had delivered to another residence, had it set and skirted and hooked up without county approval. They knew that they were not approved with this current zoning regulation for what they wanted to put in. They asked for approval to put a 3rd residence on land where there are already 3 places that people are living in on their residence right now. The main house, they have a little 5th wheel over by a fence line that's all hooked up, and then another structure. So what they're wanting to do is actually add a 4th. They admitted at the time of the hearing they did not bother the county application for septic plans and just got ahead and put in a system without inspections. The application also states that we want to use a cistern for water and not hook up to the water tap, although there is a Montezuma County feed line in the roadway. I have a feeling in a reality that they will not haul their water, but rather tap in or run a line from their existing tap, thereby avoiding the tap fee, but still drawing water down from other residents in that area. That's just my opinion on that. Of the 25 parcels of land within about a mile of the Lewis's, 17 do not wish for this changes to be allowed. They feel that they went against deed restrictions. It's a dilemma for you, for the county commissioner, to decide on this dispute. On one hand, the Lewises have already placed and gotten a resident ready for use illegally, and it would be costly for them to remove it. On the other, if you approve it, that's talk about setting a precedent. Other people conclude that if they just go ahead, do whatever they want, without proper procedures, without the county approval, that the county will do very little to protect other landowners, adjoining landowners, and/or enforce the land use codes. Talk about opening Pandora's box. You're just opening it up for anybody to do whatever they want and forget about rules and regulations. So please listen to what the other subdivision landowners have to say and think about future applications. And there comes a time, and I know this can be hard for a lot of people, but just bite the bullet, stand your ground, and say this isn't right. Don't allow these people to just plow ahead. I believe this is a case where one party just said, use the old saying, let's just do it and see what happens. And stepping on other landowners' rights and expectations to achieve their own wants and blatantly ignoring rules and regulations should not be awarded. Please listen to the other landowners, and I thank you for the time.
Thank you. Next.
Ms. Purcell,
Mike-
did you get a copy of what was submitted? I'm just gonna give you mine, all right?
I'm handing out to the board a memorandum that has been prepared, that
Your
has the
name-
my name is
name?
Mike Just.
Okay.
13626 Road 35.6. There's a memorandum with citations and legal authority, together with some evidence and group exhibits. That memorandum contains the signatures of more than several landowners that are in Summit Lake West Unit 2. Just in response to what Mr. Baxter had said, I believe that the land use code contemplates that the board can, in fact, consider both restrictive covenants and deed restrictions in determining whether to permit a planned use development, as in this case. We believe, and if you look at Group Exhibit A, that deeds throughout the subdivision do contain both protective covenants and deed restrictions, which state that each parcel shall be limited to a single-family residence. And in fact, the deed conveying the property to the Lewises, the current landowners, specifically states that that it is subject to restrictive covenants, as shown in deed recorded in Book 478 at page 513, and that is Exhibit B, the second page of that exhibit. And if you refer to that deed, that's Book 478-513, it does contain that same restrictive covenant language that has been referred to in the previous letter by the previous landowner. All of this is consistent with the land use code. The current zoning is residential ARES, and under the land use code, that is defined as one primary single-family residence or one modular home or one mobile home. I would also like to direct the board's attention to Exhibit C, which is a decision that was made by the board previously regarding Summit Lake West Unit 2, our subdivision. And in that case, the developer wanted to take a 53-acre parcel and split it into 4 to put up 4 separate homes. The board determined at that time, that the developer would need to obtain the written consent of all the landowners in Summit Lake West Unit 2. And why would the board decide that unless it was interpreting these restrictive covenants and deed restrictions as prohibiting anything more than one single-family residence per parcel? The other thing that the board required back at that decision time was that the road be brought up to county specifications, and there is no dispute in this case that that road, 35.9, is not up to county specs, which brings in the issue of threshold use standards. And there is an email from Mr. Baxter to John Lewis Kelly that states that the road is not up to county specifications, and you can also see from Exhibit F that there is no winter maintenance. That's a photo of a sign. So more recently, the board has ruled for Summit Lake West Unit 1, our neighboring subdivision, that when they required that when somebody wanted to do a zoning variance, that they were going to have to get the written consent of adjoining landowners. So I know I'm out of time, but I would say that for all of these reasons, as well as the others in that memorandum, that the Planning and Zoning Commission was correct in denying the application of the Lewises in this case, and I would ask the board to affirm that decision. Thank you very much.
Thank you. Next.
Good morning. My name is Roy Gelbhaus. I am a landowner at 35561 P.2 Loop, which is adjacent to this subdivision. And I would like to speak about the water situation. I have here, and I'll run it around in front of all of you. I have here a map of Summit Lake West Unit 2, and this is actually picking it up from about a mile south of 184. So it's Unit 1, Unit 2, both being fed by roads 35.6 and 35.9. Makes sort of like a loop for water distribution. Those are only 3-inch lines. And off to the side in the southwest corner of this, or excuse me, southeast, is a line that's continuing along these 40-acre lots. So this is a long distance, and that is only a 2-inch line. Steve Bowman of Montezuma Water tells me that when people come with large parcels and they want to know what size line do I need, he's telling them 2 inches. Here we have 2 inches covering a long distance for 8 parcels. So you can see how there are 40-acre lots, with the exception of the Lewis's, which is right about in here. And so the problem that we have is that this was a balanced system. This was done before computers. But this was the idea of make sure that you have enough water and to feed these number of 40-acre lots. Now, the Lewis's didn't subdivide that, but it did happen. So there you had additional demand. There's talk right now, the study came out, 2080, Colorado's supposed to be like Arizona. When you look at an overhead view of Phoenix, what do you see in every backyard? A swimming pool. So even the evaluation from Montezuma Water presently is not taking into account the future demand. The Colorado River runs out before it reaches the Gulf of California anymore. Frankly, Mr. and Mrs. Lewis, what we have is a situation where Benji may not be able to get the kind of water if everybody does what you're asking, because they're further upstream. It could run out before it gets down to you, at least at sufficient pressure. So, which leads the question then, if there is insufficient pressure because we've unbalanced the system as it was designed, who ends up paying? And this 2-inch line has to supply all these people, and yet because the way that the subdivision was done previously of taking a 40-acre lot, thank you, and dividing it into 4 lots, what that has now been taken by planning and zoning to be precedent. And I will show you just
Okay.
one
I'm
quick
gonna-
thing,
I'm gonna go
an
ahead.
application that was made.
Your time is up, sir.
Okay.
I think you can present that, but
This was
I have
lot
to give
21.
everybody else the same respect to have the same time.
This was lot 21 as it was backed by planning and zoning
Okay,
with 10
all right.
on 5 lots.
Thank you, sir. Next.
Thank you. Thank you for your time and letting me go slightly over. Appreciate it.
My name is Glenn Haney, and 304 Pawnee, McCook, Nebraska, 69001. My wife and I were talking a little bit about this, and we may be the only 2 surviving original members that created Summit Lake West. And in general, what I would like to say is that the grouping, which we were a member of, and I was vice president of the group, that our intent for this development was for residential housing. I would be glad to answer any questions that anybody might have in regard to that. But that's a statement that I would make.
Okay, thank you.
That, we created that development in the 70s. And probably some of you know Glenn Gentry, remember him or whatever, and he was the president of the organization when we did this.
All right, next.
Morning. George Nelson, 13381, Road 35.9. 2 years ago, when we purchased and looked around to come and move up here from Arizona, which I've been an avid hunter up here for 40-plus years in this general western slope area of Colorado, we didn't proceed down the road further than our house when we looked at it. It was after we bought. Finding that I know in my deed restrictions, which I'd left laying on the table when I came to the meeting this morning, but it does mention about the single wide, the double wide, and the modular. And there is an older single wide trailer currently on the Lewis's property. And then I can say clearly, being the next door neighbor, half the truth has been told on some of the stuff about when and where. I lived there. I seen. It was done like there was no worries. You said the perfect thing, Jim, earlier. Ignorance of the law, basically, is not a relief of responsibility. One of the original survivors, and actually the son of the man that started it, is in the room today. It's a sad choice that you can't do anything you want in America, but you got to have boundaries, rules, regulations, in order to be equality. You said it perfect, Jim, equality for everybody in consideration. The sad thing is, I invested in an investment. A home is an investment. It's not just a residence. Your plan is to either make it a viable resource later in life, to pass it on, or whatever the case at hand being. But I feel that as we make things smaller, more incumbent with necessities, without the infrastructure to accept it, somebody's going to pay for what? And that goes for the whole county. There's so many developments going on as I run the roads, the difference in learning the county even better of ins and outs and what we have out there. There's some beautiful places out here. Beautiful. Mansion type places. And then there's a trailer trash. Not indicating anything to do with this case at hand. I'm talking about there's old trailers just scattered all over this county. Disrepair, bundled up, junked up. But that's not what we're here for. What we're here for is not following the rules and guidelines. The incumbents, the deed restrictions, that all should apply because that is part of our investment in our home. And I think everybody's pointed out, I know my time's up, everybody's pointed out, we don't have the infrastructure. Just to let you know, I got into a big argument with your foreman of roads before winter hit last year, and I was not appreciative that he doesn't realize you don't talk to your people that pay your wages like that.
Okay.
And a threat was made. I ain't gonna do your roads no more.
Thank you.
Thank you.
All right, next.
Good morning. I'm Lisa Gower, 36079 Road N. And you moved the map, but we're sort of kitty corner to this property. Most of what I wanted to say has already been addressed, but I wanted to emphasize the water situation. We did not see a cistern going in when they went ahead and set this trailer. Maybe they did. We couldn't see it from the road. But even if they have a cistern, they've already said they can't afford a water tap, they probably can't afford to bring in water. We suspect that they're gonna be pulling off the tap. We live on Road N. Oh, yeah, there we are, in the right-hand lower corner. My daughter is an environmental engineer. She's the project manager at the moment for the town of Silt. She's redoing their entire water and sewer system for the entire town. When I told her we'd found out that we had a 2-inch water line, a dead-end line, she was stunned and said that that's barely adequate for what we have here right now. She also did some calculations for me. We're about 60 feet above the road where the water line is. That's where our house sits. You lose pressure with every foot of elevation. 0.433 PSI of pressure for each foot. That comes to just under 26 feet of pressure. Montezuma County only guarantees us 35 PSI. That takes us down to 10. That's where we are right now. We've talked to Montezuma County, and really the only thing they can do is upgrade the lines. And that isn't gonna happen anytime soon. So the more people who tap into this water line, we've already got 3, there is a 5th wheel there too, 4 residences we're talking about on a 40-acre lot that's already been subdivided into 4 pieces and is already drawing more than the original developers planned. Where does that leave us? And we're on this end. The other 7 properties are further down on this dead-end line. Where are they gonna be? So we really feel strongly that we should stick with the original intent for the subdivision, as the gentleman before me said. And we need to be careful of our resources. We bought our property, this is our retirement home. We bought our property because it was 40 acres, single-family residences, wide open spaces. And it will lower our property values if we don't have any water anymore, or our water's non-functional. So please, please do not set this precedent of subdividing these properties and hurting the rest of us downstream. Thank you. Appreciate your time.
I just want to make one clarification to everybody out there that's listening. Montezuma County does not own water. So in your
I
statement.
meant Montezuma County Water.
Okay, that's Montezuma Water Company.
I
We, as a county, have no ownership in any public utility as far as water.
I understand. I was referring to
Okay,
Montezuma County
well,
Water,
I'm
sorry.
when I hear something incorrect, I just like to make sure that I set the record straight.
I apologize
just so
if that wasn't clear.
And that's fine, I just want to make sure that everybody realizes that, because municipalities do, we, however, do not.
Understood.
So that was one of the questions that we asked planning prior, so thank you. Next.
Whooping stick. Good morning, William Gower, 36079, Road N. I just wanted to point out a couple of things, if I may. This is our property here. This is our property here, the corner. This place here, that's where originally the trailer they were talking about that had burned was removed. Now there's a 5th wheel in its place that's been occupied for almost a year. There's also the temporary leach field and septic that Wade was talking about is right here. They cut in a road right here over to the new trailer. So the new trailer is placed here with another septic system here. And then you've got Justin's trailer and then Ed and Betty's house over here. So you've got this 5th wheel, which I think is going to stay there because it's already hooked up to another leach field. And then you've got this trailer that they've already placed. So I just thought I'd point that out to you guys.
Okay.
Anyway, that's all I have. Thank you.
Okay, thank you. Next.
Mike Lynch, 21730 County Road S. As I was sitting in the audience, I've heard a couple references to this property as being subdivided, but the pictures that are being shown doesn't show any subdividing of that property. It seems like there's some confusion there that maybe you could straighten out.
Thank you.
Good morning. I'm Cheryl McMillan. I live at 13124
Can pull it down.
35.9. And I just want to talk a little about some of this that's been going on. Number one, I don't understand why a cistern would even be considered. I find in the land use codes that it isn't allowed if water's available. So I would think a water tap would be necessary. And yes, I have to concur with the other residents. We have very poor water pressure. And in reading the land use codes, it seems that a partial purpose is to mitigate adverse effects on others, we citizens. And I don't think that this is going to help our health or safety if you allow this. And I also want to point out that this mobile home that sat in the corner, it sat there for about 10 years or more, and the roof was blowing in the wind, and insulation was blowing down the road, which I went out and picked up. When I consulted with our environmental health department about it, because children were playing in this insulation, they said there was nothing they could do except maybe talk to the landowner and ask them to help the situation in the neighborhood. So I just want to ask you to please don't let this get sidestepped, because I feel that our safety and health are definitely at risk here. And in listening to the comments today, I don't think that we can put trust in these people to do something after the effect of what's to be done. I think that we need to make certain, I hope so, that it's in order before any continuation of this development is progressed. So I implore you to please seriously consider your true views on this matter. Thank you.
Thank you. Next. Okay. With that, I'll close the public comment section of this hearing, and I will bring it back to the commissioners. But I do have one clarification. This is, which is a question that I had in the beginning, since we're looking at a planned unit development, not a subdivision. Where is a plat that even shows how this would be separated out as far as a PUD? I mean, is there, we don't even, so I don't even know what I'm looking at. How would this be divided? And I know you can't answer that right now because this is all we have. But just for that clarification, we're not looking at a subdivision, we're looking at a PUD. So with the PUD, typically what we see is a plat that's presented to us that shows what the lots are, how many lots there are, X, Y, and Z that goes along with the plat, which we don't have that in front of us today. I did make the clarification that Montezuma Water is its own entity, not owned by Montezuma County. So I'm gonna ask you all, since you live in that subdivision, what, as far as the compliance with the covenants, and I know that we don't necessarily, we don't enforce covenants, that's enforced by you all per our attorney.
You may consider them though, and encourages you to consider them, but
which obviously, you know, that from the testimony we'll consider those, but have the covenants, I mean, do you guys have annual meetings? Do you have regular meetings? How do you go about your covenants and get into this type of a situation, I guess is my question.
Homeowners association, there's none.
So do you realize that you do have covenants on this property?
Just what's on my deed.
Their deed restrictions is what they
So-
are in
okay,
this
so-
situation, which refer to covenants from
the
this
next
unit
unit,
one.
right.
Yes,
Right.
and it's again, it's their deed, the one that I'm looking at, is actually different than what everybody was saying. It's missing the word no on it. So I wouldn't get too in the weeds about that. I think that the main thing for you all to consider is adverse effects to neighbors. And that's why, if in fact it isn't in alignment with covenants or deeds, it should be a factor to be considered if it's adversely affecting the neighbors.
So the adverse impacts of the neighbors, I guess I'm asking, planning and zoning recommended to deny this. Was that because of the adverse impacts that they saw also? Or was it water because?
It was more the legality of deeds versus covenants versus the land use code. And also the fact, just because they proceeded and set the unit when they weren't supposed to, which added to the situation.
Sure.
Three mobiles have been there for years, so I don't know if it changes the scenario. This isn't something new, it's replacing one that had been there, so I don't know, it's a better visual impact, I guess, because the old burned out one's gone. The water situation, all we go by is what Montezuma water says. If it's not an impact to their system, I mean, that, they would have to disclose that, that's not our call, our judgment.
Sure, no, and I understand that. We're just looking at the land use code. Does it or doesn't comply with
That
the land use
parcel
code?
was split before the Lewises owned it. If you look to the east side of 35.9, that was part of the 40-acre parcel, and it was absorbed by that other lot. I mean, this was all split up prior to the Lewises and the land use code. So I don't know that that has any bearing on anything here, with what they've done since that time. It is limited road maintenance. The Lewises actually maintain that road in the wintertime. I don't know what and how far, the extent north and south.
I think there's a cul-de-sac, if I remember that road, to the north, but, I mean, that,
I'm not sure I got anything else to say. Yeah, it just all came about when they were needing a new address, a corrected address for delivery of that unit. And then we went through the process, explained to them what was required per the land use code, what they would need to be compliant, and then it's proceeded from there. Planning and zoning didn't really elaborate on, you know, which way to view this. With the legal questions concerning deeds and covenants, lack of covenants, deed restrictions, and how that fits the land use code. Barring anything else, it does fit the parameters of the land use code. Your question would be, they are not separate PUD lots. It would be 3 units contained on one parcel, and that commercial envelope would be the frontage of that parcel, the eastern, probably maybe a quarter or a third, just to encompass the residences. It would only be a commercial envelope, so that they pull all the mobiles out, it still stays AR zoning.
so then you could put another mobile, or you could put another home on the backside of the property? If it stays?
If this PUD was approved then you would have to amend that PUD to add another residence. You're allowed two per the land use code. That doesn't,
It's out of compliance right now.
that's out.
Correct, because we have 3 right now.
Right.
And okay, questions, commissioners?
Comment. I mean, planned unit developments were originally intended to cluster the homes on acreage that has the size to fit the 3-acre minimums, which this does meet. But there's no, I mean, the key word here is planned. There's no plan for this. We're not seeing anything drawn out. We're not seeing anything here. We have, well, we may have a water tap. We may have a sewer septic inspection. You gotta draw a line somewhere. And this may be it. Gerald?
Commissioner?
On the original 40 acres that this 13 acres come off of, was the deed restriction the same as these others?
No. I mean, it was, yes, sorry. It was the same as the other deeds. I think that their deed, and this is just me surmising, is a misprint. So everybody else's has the word no in it. Theirs does not. So it must have been a mistake. Yes, had to have been. But again, I'm just guessing.
Which is something that's gonna have to be decided in a court of law, not here.
Right.
Yeah, that's not for us to, ours is just, is it compliant or is it not compliant? And right now, it's not compliant.
It's not compliant, and unless you all go against the P&Z recommendation and go against planning, it's out of compliance. And so then you all are gonna have a decision to make that, we can talk about later at another place, another time on, because basically that'd be an order to remove one of these homes from the property so that they get into compliance. And if it's not removed, whether or not you all want to pursue legal action, to start fining, and if the fines aren't paid, then take over the property. Because right now it's out of compliance.
Right.
And so if you all approve this, then it'll be in compliance. It's okay, it's above board. But if you don't approve it, really, they're gonna have to get into compliance. The neighbors could enforce it by their covenants and how they interpret those. But they're gonna be out of the land use code compliance if they leave it as is right now. And so then the question is, do you all want a legal action to force them to remove it or end up with the property?
All right, any other questions for the applicants or planning? I think we've heard everything that we need to hear.
One thing that we would like to add, the water line that he was talking about was the original water line, and since then, there's been a line come south on 35.9, and Wade can tell you more about that.
The line comes in through Pewitt, comes back through that new subdivision, and it ties into that line, and runs around the backside. And that's a 4-inch line, it all ties in, and I know that because I put it in.
And the sewer, also, that guy was talking about 2 sewers.
All right,
Not 2 sewers.
well, gentlemen, we have a decision to make. I think we've heard all of the testimony that we're gonna hear now.
I have one more question. P&Z's reasons for, just to
You
restate
just said
them.
it was the deeds and the restrictions. of the
Reasons
deeds.
was, the deed restrictions, referring to Unit 1's covenants, rather that legally applies, it's way above P&Z and my pay grade. As far as they didn't have a real problem with the PUD as meeting the land use code, they just weren't real thrilled that the unit was set with a new septic system installed the week prior to the P&Z meeting.
Okay. Anything else?
Nope.
All right. Commissioner? All right, what's your pleasure?
Sure.
Well, personally, I think that once that deed restriction was put on that 40 acres, even if it was subdivided after that, that restriction still should be on that property myself.
I
That
mean,
deed
I agree
restriction's
with
on
that.
there.
So you were,
And I'm not going against the deed restriction. I'm not.
okay,
I just,
so would that be
I
in a
can't.
form of moving it as?
I move we deny this proposed plan unit development
Okay,
for Edward and Bette Lewis at this present time.
I'll second that.
okay. So it has been moved and seconded to deny this proposed general planned unit development and rezoning application submitted by Edward and Bette Lewis on property located at 13301 Road 35.9 Mancos, Colorado, consisting of 13.54 acres more or less. Any further discussion?
No.
Okay, all those in favor?
Aye.
Aye. All right. So, this has been denied. The restrictions are there, so, we'll figure out what we have to do as far as this going forward to get that into compliance, because those restrictions do, apply on Unit 1 and Unit 2. Do you understand that?
Do we need to have our deed redone since,
So basically, you can only have one other,
I understand that, but on our deed, if it's a misprint, how do we need to have that redone?
that's, I'm gonna have to let the attorney.
We can't give legal advice on what you need to do with that. So you certainly should and could consult with an attorney about that. But as it stands right now, your property's out of compliance with the land use code, not just your deed restriction or non-restriction, however you interpret it.
So we're only making a decision on the land use code. That's not the deeds, that's something else that you all would have to take up, and that would be into a court of law. That's not something that we do as far as deed restrictions. We're just saying that as far as the land use code, it doesn't comply with the land use code, and that's our determination, that's all, just the land use code. That's a legal matter there.
Is there something we can do to get it into compliance?
Well, we're gonna have to get it into compliance now, so you'll have to get with Dawn and find out, because in reality, what that means is that something has to move. Something has to move out of there, because per your covenants and your restrictions, it only allows you one other unit there, and you have three. I'm assuming that, the mobile home or the RV is going to move, so that's easy to take care of, but here again, it's out of compliance, so you'll have to get with Dawn to figure out which one you want to take care of to get it into compliance.
On our deed, it doesn't say, one or two, it just says residences, single-family residences.
Right, I think really what Commissioner Candelaria was stating is, it's out of compliance with the land use code. You're not allowed to have more than one residence plus one more. And right now, there's multiple residences. And so whether or not it's out of compliance with your deed, and I understand they're allowed to consider that and they can base their decision on that, but it's still in violation of the land use code, in my opinion. And so, regardless of what you were allowed in your deed or not, you're only allowed to have the residence plus one other residence there.
Which is what we consider an auxiliary dwelling unit, basically an ADU. And you currently have more than one ADU. So to be compliant with the land use code, we have to try and get it into compliance here. So that's something that you guys can talk to planning and see which is the easiest thing that you need to do to get something removed to become compliant. Does that make sense?
If we get into compliance, we start over with this procedure, or does it change?
Well,
I would sit down with planning and zoning and visit with him first, see
So,
where he's
so
at, what
go
you can
through the
do.
entire land use code to see what you have and what you have not to do. There's obviously, have you guys seen this map? You saw this presented. There's not one of your neighbors, or there's 17 out of this, that are gonna enforce these deed restrictions. So I think you're gonna end up in a court of law. Now that's, I can't, you know, say you will or you won't, but from what I've heard today, I would feel that you're gonna end up in a court of law if you don't come into compliant and stay within those deed restrictions. So,
So even if you do that and start over, we're gonna end right back here and they're gonna do the same exact thing again.
well, you potentially could end up in a court of law, which is gonna be a determination by a judge of, you know, a different matter. We can't talk, you know, make any decisions about that. Ours is just now, you're out of compliance with the land use code, and now we have to bring you into compliance with the land use code, and you're allowed 1 ADU on the piece of property, and right now you have 3. Is that correct, Don? Is there anything else I need to state?
No, and I'm not sure what options we can give them. I mean, either you pull one off or you try and subdivide. That lot's been subdivided in the past, so I don't know if that sets a precedence. I don't know that the deed restriction says you can't subdivide.
I didn't read that in there.
So
But
that's,
I could be wrong.
that's
Hold me to
something that you guys are gonna have to figure out with planning now. But as far as the PUD, this application, this one has been denied. So, and I definitely recommend, here again, I'm gonna make the same statement earlier, you know, I don't know what we have to do to make it known that, you know, permits are required, the engineering design is required upfront prior to installing anything. Just so that we know that everything is adequately done, and I'm not saying that it's not, but without that prior to, it's hard to, you know, prove. So that's the determination for the day, so we'll have to let that go back to you, Don, and look at it and see if there's anything else you can or cannot do, but I would probably say that due to the adverse impacts of the deed and the restrictions on it, that you know, if you move forward doing something else, you probably will end up in court.
I've heard that you could take a mobile home and attach it to your house and call it part of the same house. Is that true or not? There's no restriction in the land use
Not
code
heard that,
as
but-
far as an addition to an existing residence. Our building code is a UBC 97 edition, which probably doesn't really address that at this point, cause that code's hard to find. If it's one residence, it's one residence. You can't have a breezeway connecting
Correct.
two
It has to
residences.
be- it would
It
have
has
to be
to
attached.
actually physically be a solid wall connection.
And put on a permanent foundation.
It would need to have a foundation.
So we have an assessor here, I'm gonna let her speak to answer the question.
Even if it is permanently attached to the house, the mobile home always remains a mobile home. So it would still be assessed as a mobile home attached to a house, it would be separate unless you could purge it together, but we would never recognize that single wide addition as a residential structure, it would always stay a mobile home.
Okay. With that, hopefully that answers your question. I've never actually had that posed to us, so I'm glad you were here. Leslie, thank you. Being no further questions, we're gonna go ahead and move on to our next public hearing. Thank you all.
I'm gonna grab Mr. McLaren.
And I'll close this public hearing. We're also gonna take about a 2-minute recess here.
Well, that deed restriction on your two lots, you're on the first 40 acres. You should have gone through and got that on the deed and just preserve that. You're still flat.
Hey, John, I looked at that map, so your parents must live right, they live down, yeah, just a little further.
Yeah.
Yeah, I grew up.
You told me they lived up there somewhere.
Okay, we're gonna go ahead and proceed with our 9:20 at public hearing.
I can start.
Okay. Are you ready? All right, we have another public hearing. Kim, would you go ahead and call the roll?
Commissioner Candelaria.
Here.
Commissioner Lindsay.
Here.
Commissioner Copenhaver.
Here.
Attorney McLaren.
Here.
Kim Purcell, Montezuma County Clerk and Recorder. Notice is hereby given that the Montezuma County Board of County Commissioners will hold a public hearing for review and determination of a proposed amendment to lot number 3 of the Aldine Acres 7-lot major subdivision and rezoning application submitted by Richard and Melanie McDonald on property located at to be determined Road M, Cortez, Colorado, consisting of 3.85 acres more or less, located west of Highway 145, north of Road M, situated in Section 12, Township 36 North, Range 16 West, N.M.P.M. The hearing will be held Tuesday, July 12, 2022 at 9 a.m. in the Commissioner's Hearing Room, Montezuma County Administrative Offices, 109 West Main, Cortez, Colorado. Interested persons may attend and give input. Information may be obtained from the Planning Office online services at https://montezuma-co.smartgovcommunity.com, public home. You may also contact the Planning Department at 970-565-2801 with questions. Dated this 14th day of June, 2022. Kim Purcell, Clerk, Board of County Commissioners, Montezuma County, Colorado. Published in the Journal on Wednesday, June 22nd, 2022.
Okay, thank you, Kim. Don, go ahead and give us an
All
overview of
right,
this.
I have Rich McDonald here, the applicant, and they are proposing to change the zoning in lot number 3 of their Aldine subdivision. The property lies adjacent to Highway 145 and County Road M. It's within the commercial industrial overlay zone. We did not receive any feedback from CDOT. I believe Rich talked to them or attempted to contact them. It's been not very productive getting them to respond. So we don't have any feedback directly from them. The access to that lot is west on County Road M, adjacent between lot 3 and lot 4. Planning and Zoning was unanimous to recommend it for approval with the condition that the covenants be changed to state that if this is approved, that lot number 3 is commercially zoned.
Okay. Have a second to,
We just wanted to make the highest and best use out of the property, and being on that corner, we thought commercial use would be suited well, and we're not sure if we're gonna do something with it or ourselves and make it commercial. I mean, do something after it is commercial. But we just wanted to have it already done, and
okay. So it does fall in the commercial overlay is all they're asking for is to add that so that the other people would know that lot 3 is a commercial lot, which is not a big deal at all. Do you still own lot 4?
yes, we do.
Okay. So nothing has been sold there, so everybody coming on the backside of it would know that lot 3 is a potential commercial
Yes.
overlay.
When we,
Okay.
when we subdivided the whole thing, we sold off the big house out in the middle of the property, and we have a letter from that homeowner understanding and not having a problem with
A
it being-
non-opposition letter?
Yes.
Okay. And we have that on file.
I've got it in my truck, I'm sorry, I didn't bring it.
Okay. So I guess my concern is still CDOT. We don't have anything from CDOT at all?
We contacted Randy Ryder numerous times with no avail. No response whatsoever.
Agency notice went to them May 25th.
May 25th.
I emailed them last week and again yesterday. I actually included Dan Rusin, who is the state access permit manager, who has been involved ever since the previous access manager left our area, but I've had no response from him either.
So it's compliant with the land use code, it's just a matter of the agency responses, so.
Ultimately, our job is to send the agency notices out. I mean, if
Correct.
CDOT doesn't respond, we can't read their minds.
May 25th was
Yeah.
when we send it?
Right, and I believe the land use code states 10 or 15 days time frame for an agency response, or I guess you snooze, you lose. But you know what CDOT's been saying all along now, they want the county to get access permits to every highway entrance. So, and I'm not sure without knowing what business may or may not go in there, a residence goes in there, you can't do a traffic count, you can't do a projection, so.
Well, the beauty of this one is there is a AC/DC lane on M Road.
Correct, yeah,
So
the only
that-
upgrade would be
That's a good thing.
right.
Something to County Road
Yeah,
M.
the only question would be the proximity of that driveway for commercial to that intersection, but, I believe, what is it, 350, 400 feet?
I believe it's 300 and something feet.
Yeah, so I mean, and CDOT's typical, who knows now, they changed all their stuff, they got a new regional person, and I don't know what they're doing. Was 350 feet from the intersection, but,
Well, the attorney said, we've done our job, now we have to make a determination. So, Commissioners, do you have any other questions?
No.
Yeah, you've only sold that one lot.
Correct, we've only sold that one lot, yes.
And this isn't gonna be any sort of common ownership interest community or anything like that, right? This is just there's no common areas or anything
No,
like that?
there are no
Okay.
common areas.
Gotcha. Okay.
So you have a non-opposition letter and you own the lot next to it?
I
Lot
own
4.
everything.
You owns
all of it.
you owns everything around it.
Everything.
Right, so,
Yeah.
so to add that, yeah, that, okay. good.
And Mr.
All right.
McDonald, if you have that letter, I would just ask that you do submit it to the record. I think it would be helpful to have that in the record.
Yes, I do.
Okay.
And I've got the amendment to the covenants. I just haven't recorded it yet. And, yes, I will add all that to the record.
Okay. All right. With that, then I am going to open this up to public comment. Anybody wishing to speak for or against this application, please come forward, state your name and address for the record, and you may address the board at this time. Okay, seeing no public comment, I'm going to close the public comment section, and I will bring it back to the commissioners. Do you guys have any other questions or comments?
I do not.
I don't either.
All right.
Commissioners, you can certainly make this approval contingent on submission of those documents to the record. I think that would be a good idea here.
Okay.
Because I think it will make the record more whole and protect you moving forward.
So we will include the non-opposition letter and the,
And I might have misspoken if it's a non-opposition letter. We made an amendment to where the property, the only other property owner signed off and notarized that the lot would be commercial, never industrial. And she signed and notarized that. So I don't know if it's truly a non-opposition letter, but she is okay with that.
she is aware that
It
this
will.
lot is going to change to commercial.
Yes.
Okay, that's
Not an-
what we're wanting to make sure, that that person that's already purchased a subdivision that was all residential now has changed.
Yes, I'm just
To
saying,
be
I just
fair-
wanted, verbally, I don't know if it is a non-opposition letter or if it's just
Okay,
stating the fact that she is aware and she has signed and notarized a letter that this will be commercial and never industrial.
okay, so I think we want the non-opposition letter is what you were,
Yes.
where you were headed?
If you would like,
That's where-
we can present our boilerplate non-opposition letter for execution,
Okay,
just so we've got them both on file.
Okay.
Yeah, I mean, a non-opposition letter is not a necessity here, but it certainly
No,
is
but it's-
helpful for shoring up the record and making sure that everybody here understands what's happening.
For
And so,
future, for
yeah,
future.
for the future,
Yeah.
for somebody else buying lot 4, lot whatever, and the person that's already purchased it knows that now it's changing.
Yes.
So
And
the
covenants will be
non-opposition
changed.
letter is very, very good.
Okay.
Okay, go ahead.
All right,
Commissioner.
I so move we accept the proposed amendment to lot number 3 of the Aldine Acres 7-lot major subdivision and rezoning application submitted by Richard and Melanie McDonald, property located to be determined Road M, Cortez, Colorado.
and Commissioner, are you making it subject to the receipt
Yeah,
of the?
contingent upon the receipt of the letters of non-opposition and information, not information, but informed
And the
consent.
amendment,
Is that?
I-
Informed
Well, it
consent
depends
of
what
the
you're
neighbor.
looking for. If you want a non-opposition letter.
Yeah,
then-
let's just leave it at non-opposition letter
An amended covenant.
and amended plat, yeah,
Amended covenants.
amended
covenants.
that states it's a commercial
We'll
lot.
get there.
Second.
Okay,
Gerald, you gonna second all that?
it's been moved and seconded that we accept the proposed amendment to lot number 3 of the Aldine Acres 7-lot major subdivision and rezoning application submitted by Richard and Melanie McDonald on property located at TBD, Road M, Cortez, Colorado, with 2 restrictions. One, we have a non-opposition letter of the submitted, and that we also have the amendment to the covenants. All those in favor?
Aye.
Aye.
Aye. Okay, I will close this public hearing. All right. Moving right along, the Board of County Commissioners welcomes you, I'm sorry, Don. We're good to go.
In other words, get out.
No. I apologize.
That's all right, we can be
I am
done.
I'm looking at my schedule and I am so far behind that I'm never gonna catch up.
We'll say goodbye and let's move forward.
All right,
Thanks.
have a great day. All right. Now we're gonna move to the public comment session. Board of County Commissioners welcomes you to this meeting. Person speaking during the public comment will be limited to 3 minutes, or depending on the number of people wishing to speak, it may be reduced to allow all members of the public the opportunity to address the board. When addressing the board, please state your name and address for the record prior to providing your comments. And comments to individual supervisors or staff are not permitted, and you may not yield your time to others. With that, the public comment section is open.
Good morning, folks, and thank you for the opportunity. My name is Alan Mays, 21693 County Road 21 in Lewis. I just want to say this meeting shows again that there's a lot of stuff that comes before you folks, and you do have to take the time and consideration of these last two meetings that I've attended. There's been some issues, and you have addressed them well. This land use code is one that I appreciate how you did cover that. There are rules. People need to know that there are rules. How to educate the community on that, I hope, is through the transparency that you folks try to do here. But anyway, that is something that's out there. Everybody knows that organizations, entities all do have rules, and we do need to just try and follow those as clearly as we can. One other thing, though, a previous county commissioner meeting, the social services reported, and it is a concern here in Montezuma County, the things that we're seeing out there. There are more people on our streets, whether they're homeless or just people that are hanging out in the streets. But that is something that I hope can be addressed some way. You see it in the city of Cortez, and that is an issue more for them, but it is here in the county, and that reaches out to the county, and it can cause problems, and we know that it is, whether it be more people being on roads just because they need a place to hang out, or if it's the drug issue. And so I do know that hopefully those things can be addressed, and our community can be made better all the time. So thank you for all of the things that you take into consideration here. Thank you.
Thank you.
Mike Lynch, 21730 County Road S in Cortez. Good morning. I've heard you at 2 meetings now concerned about being asked to approve applications after the fact, and wondering what to do about that in order to educate the public. And I'm wondering if you might make a suggestion as to how the public, if someone in the public has some ideas about that, how they might convey that to you, if it would be by using your email, or if it would be at a meeting such as this in the public comment. What method would you prefer for those suggestions to come into you?
Okay, thank you. Do you want to address that, either one of you, or we don't have to? We're still in public comment. We can come back.
For me personally, you can go through my email, here at the county. You can call me. You can even come see me. I'm open to everybody, so it doesn't matter.
And that's fine with me too. Our numbers and stuff are out there, so you can call me or whatever. Doesn't matter.
And I would go as far as to even state in a workshop that workshops, we have a lot more time, and they're just for discussion and planning, and a lot more can be done in a workshop than actually here, where we're actually having to make decisions. So we welcome anybody's input, because everything that we have out there, our mode of transportation for informing the public, obviously does not seem to be working, because or it's just total disregard of the people. So thank you. All right, anybody else?
Yeah, we're not the only ones that face that.
No.
I mean, the boards that I've been at to
communication, I mean, not to stretch this out, but everybody used to read the newspaper. Well, circulation is down with the newspaper, so they get their information from such a wide variety of sites, you know, and it's just tough to communicate directly with our people. I mean, some of our information is posted on our website, most of it that we can think of to get on there, so.
All right. Anybody else? Okay, with that, I'm gonna close the public comment session. And I'm gonna skip our agenda because I see our public lands in here, and I typically try to get them up here at 10 o'clock, which I have failed miserably today. Derek and Casey, if you guys wanna come forward, I'll get your report, get you in and out. Okay, so it doesn't look like we're gonna have Connie or Ray here today, so we'll just be hearing from the U.S. Forest Service and Mesa Verde National Park. Welcome.
Hi, good morning.
Good morning.
See you all again.
Hi.
So I don't have too much today. Just we'll be releasing the Beaver Pit gravel, the Beaver Rim gravel pit EA tomorrow. So that'll be on the streets for 30 days. We had originally planned on doing a CE categorical exclusion because we had a category that allowed for a 20-acre or less site for this, but it was decided that the old pit, which was about 20 acres in itself, counted against that 20-acre limit associated with that CE. So because of that, we had to bump it up to an EA to incorporate the additional 19 acres that we're going to do, and then also be able to utilize the 20 acres as a staging site for equipment and things like that that the county will utilize. So that's the reason we had to do that. So that'll be out for 30-day comment. You know, I don't anticipate any issues during the scoping period. We only received a few comments, and they were all positive. As people see the benefit in having a gravel pit there and being able to upgrade, you know, our roads as well as the county roads utilizing that material. So any questions on that? No.
And that's the Beaver Pit, where's?
So that's one off the Dolores Norwood Road, it's right before you get to Forest Road 527. So when you go up the Boggy Draw Road, when it comes back around and ties back into Dolores Norwood Road, just about a quarter mile before you get to that junction there.
Gotcha.
Yep, off on the right side.
Up on the hill.
Or the left side, sorry.
Yeah, it's on the left
Yeah.
side.
Yeah, as you're
Yep.
going up,
Gotcha.
left side, yeah.
Gotcha. Okay. Just wanted to make sure I had it in my mind
Sure.
properly. Okay.
No problem. And then the only other thing I wanted to discuss was, you know, whether or not the county had made a decision on the Dolores Norwood Road with regards to consideration of a FERDA easement. We have a couple of road use permits that we need to issue that if the county were to be interested in pursuing a FERDA easement, we wouldn't move forward with issuing those road use permits because we wouldn't have jurisdiction of that section of road there anymore. So we just needed an answer to inform how we should proceed with our road use permits.
So I don't think we made 100% determination. I think our concern was, one is that we don't own the right of way. And again, I think I stated in an email following up with you, is the concern of the realignment or potential realignment if it ever did need to occur. Now, it hasn't occurred, but only once in my lifetime.
Correct, and as my response, you know, to your email, you know, indicated is that, you know, if a new alignment were going to occur, you know, as the subservient estate owner, coordination would have to occur with us anyways.
Right.
And it would depend on the section. Well, no, it wouldn't, because we haven't no part of an RRS 2477 assertion has been validated at this point in time. So it is still Forest Service jurisdiction for the entire section that's within the National Forest System boundary up to the Dolores County boundary. But at any rate, like I said, as a subservient estate owner, we would still have to work together, to authorize a new alignment if that were to occur. The only alignment that has occurred, like I said, I don't think you're that old, so I don't think it occurred in your lifetime.
Well, maybe I was a little kid.
Right. Yeah. It was in the 40s.
Yeah, no,
yeah.
I wasn't.
Yeah.
I'm not that old.
Yeah, and that's the reason, in total that the RS 2477 assertion, could potentially not be validated, is because of that realignment back at that time, because it deviated by about a mile and a half from the original alignment of the road there. It used to go over to Little Bean Canyon, and then that rough road up that way was the original alignment, but then that big loop there, or big bend in the road there, is where it was realigned to, and that's the part where we couldn't find any evidence whether or not, that would qualify for RS 2477, and then be able to be recognized through a non-binding determination process, is what they call it, just saying that, all indications are that this would qualify for RS 2477, but the county doesn't want to go through the legal process. We don't, want to enforce anything, but like I said, the evidence showed that it was realigned at least for 3 miles in the 40s, that then doesn't give us, the full evidence that the alignment as is today would qualify under 2477. So that's why we didn't finalize that non-binding determination process. But as I said, we are perfectly comfortable. We already had agreement then, and have agreement now, to include language in any easement saying that, in the event the county decided to pursue RS 2477 in the future, the acceptance of the FERDA easement would not, prohibit the county from, pursuing that assertion. So we've done that already several times within the state for other FERDA easements where, the counties felt that it may qualify for some sort of historic right-of-way. And then just to give that assurance, we've included that language, and we would do that in this situation as well. Another concern that you brought up was just the condition, of the road itself. We are working with the county right now to identify some dollars on the Forest Service side to be able to do some asphalt patching on the section that's under our jurisdiction. It's not a lot of money, but even that's becoming difficult to come up with. It's about $19,500. I'm pretty confident we're going to find it, but it's been a challenge, and just saying yes, let's just do that, because it makes sense. You guys are going to provide the labor, and we just have to provide materials, so that's something that we should do. So that's another reason, I think in the future it's just going to become more challenging for the Forest Service side anyways to be able to come up with funding to administer and maintain that road. And in speaking with our roads engineers, that there's just a lot of opportunity for counties to obtain that kind of funding. They just used the example of Archuleta County on the Piedra Road over there, was able to get 9 miles of road paved, and they have a FERDA easement for their section there that would not have been able to been received by the federal government, that it had to be another non-federal public road entity. So that's why they were successful in doing that. So we just, but we are still able to partner with you all, even if it is under your jurisdiction. And then lastly is just, as far as constituents here in the county, when people are hauling commercially on that road, we have a direction and by law that we have to require a commercial use road permit that then results in fees and things of that sort. And I don't know if the county does that with commercial road use operators or not, but that would go away for those folks. So at any rate, there's a lot of benefits in my opinion, you know, for having it under county jurisdiction, but ultimately that's up to you to decide. Like I said, I just need to know sooner than later.
Sure, and I had also emailed Julie Constant, the Regional 5 Transportation Director also, because we were talking about Faster, Tiger, and some of the other grants that they have. So she recommended a flap. Does that go through you guys, the Federal Lands Access Program?
She
as
probably
far as-
recommended that because it's currently under our jurisdiction. Yeah, but Federal Land Access Program, correct, goes through us. We applied for dollars through that program.
So we're unsuccessful with the flap grants?
Correct.
So we need to, if we did it, because really, I think our biggest concern is the degradation of the road that it is right now. I mean, we realize what kind of commerce that moves up and down that road. Whether it's cattle industry, agriculture, whether it's
Tourism.
logging.
Right.
We realize the traffic that road gets, but our concern is that now we're taking on another 15 miles of road, basically, because we go all the way up to Butler's Corner. So I guess it'd be about 13 miles of road, but.
Well, what's under forest
as far as-
jurisdiction's about, I think it's between 5 and 7. I can't remember. I should have wrote that down, but.
So, I guess we need to have
Our avenues of funding are just as restricted or more so than yours. I mean, we're looking at a pretty big hit next year.
Sure. I mean, if the answer is no, that is perfectly fine.
Well,
I just
sure.
need to.
I'd like to take one more look at it.
What is our time frame, Derek? Because,
Well, I'd hope to have an answer by the beginning of July, so we shot for.
Missed that.
so we're,
Yeah, missed that. Yeah, so we're shooting for June 22nd is what we were looking at, but I mean, another week or two is not gonna. I just told my folks to start working on the permits, and if things change, well, then we can just stop work on it.
So I think one thing that's important is, I mean, if this is something you guys are really serious about, we need to get a copy of what the Forest Service would propose in terms of a FERDA easement, so we can actually look at the terms of that easement. I've looked at some FERDA easements. We talked about this during the workshop the other day. You know, they can be very restrictive. It's not the same as owning a road. And the Forest Service does maintain a lot of power to do certain things on that road in terms of traffic regulation and whatnot. And so without having an actual document in front of us, it's hard to know what sort of terms are being proposed. So that may be helpful as you guys consider it, to actually get, hey, this is what we're proposing, rather than this sort of blanket, this is a FERDA easement, because some of the language in those things tends to differ.
Well, I provided one when I first proposed this, you know, but I can propose exactly what we're talking about. The only difference was that they referenced a different right-of-way act. I think it was, I can't remember which one it was. It wasn't RS-2477, but everything else would be the same.
Okay.
But said we did get pretty close to developing one for the county that I can provide, and it would be basically be that.
That would be helpful.
Sure.
I mean, again, I think the biggest issue with this is it is different than owning the road, and you know, the federal government does maintain jurisdiction. It's tricky because ultimately, you know, I think that there's good argument to be made that that's an RS-2477 road even with the realignment, and to take on a road in the condition that it's in, and then fix it and not have ownership of it. I think that's the biggest drawback of the FERDA easements, and that's kind of what we talked about at the workshop the other day.
correct, but your funds are getting more restricted for the roads.
Correct. They're just, the way it was explained to me is that they're just making more funds available for public road entities and not, see, we're not considered a public road entity, the Forest Service. We only are supposed to manage roads for management of the forest. So, you know, people accessing groundhog, people accessing their summer homes and things like that out in the national forest aren't in the purview of the Forest Service for managing roads, you know, to provide that level of service. You know, for us, you know, for our log trucks and things of that sort, you know, theoretically, if that was the only use up there, you know, we could have a lower level use road up in that area. You know, but because we all know that it's not, you know, that level of use that's occurring, you know, and that's why I say that, you know, our road, like you're saying, our ability to get funds is pretty limited compared to the counties, even though, you know, the counties are limited as well. You know, but with the infrastructure bill, it was just, there again explained to me that there's just a lot more opportunity for non-federal governmental entities for getting those types of funds.
So, Mr. Padilla, you'll have to forgive me, I'm not as familiar with all the Forest Service regulations as you probably are, but I mean, what is the possibility that the Forest Service would just relinquish that road to county control? I mean, it seems like we're kind of in a position where the Forest Service can't maintain it, and so you're asking us to take on the maintenance. Why can't we work towards just getting this road under county jurisdiction?
Because without, you know, legislative intervention, we don't have, there are no authorities for us to just divest ourselves of that road. That would be the easiest thing. But unfortunately, that's not the case. You know, the county did engage with Congressman Tipton's office to try to do that, but because there is a mechanism that gets you 90–95% there through the FERDA easement, they said, you know, that's really the best way to go and not congressional action, just because that is not something that would probably, you know, go through very quickly. So they just saw the FERDA easement as the way to go, or the non-binding determination. But in my opinion, a non-binding determination, just in its title, tells you that it has less teeth than than an easement, because it's non-binding. You know, if somebody, you know, decided at some point that they didn't want to take part in it, well then they could just make that decision. But at any rate, we did pursue those things, you know, with the previous, well, I've been working on this since, what, 2013 or so, and unfortunately just haven't, we've gotten really close, but haven't got there. The last time the county just took the position that because there was language within the permit that said the chief of the Forest Service has the discretion, you know, to terminate the permit, that they said if we took that out, they would accept a FERDA easement. But that's in the act that authorizes us to enter into FERDA easements, so we don't have the ability to remove language that's in the legislative authority that gives us the ability to do these things.
Well, and with that type of language, I mean, really what you're doing is you're agreeing to bring the road up to specs, and at any point in time.
Well, I don't think we're saying that we have to do anything more to it than it currently exists.
Correct.
You do take on certain responsibilities for that road without having the ownership and control of that road that you would if you owned the road.
Okay. All right, June 22nd, or July 22nd.
Well, yeah. You know, in
As
a
soon
couple
as
weeks.
possible.
Yes, correct.
Yeah.
And if you need more information in the meantime, like I said, I will forward the FERDA easement that we put together originally. But if you need anything else, just let me know.
Okay.
That's all I had.
All right.
Thank you.
Good morning.
Morning.
Good morning.
Thank you for inviting me to give you a brief update about Mesa Verde National Park. We're in the thick of summer visitation, but interestingly, although last year our visitation was high, we've had it drop off a bit. Our June visitation was down by 20% over last year's, which was a bit surprising. And our year-to-date visitation for 2022 relative to 2021 is down almost 10%. So perhaps this is gas prices and a number of things. But it also, for us, could relate a bit to the other briefing point that I wanted to bring up, which is the big paving project that I've been talking about every time I've come before you. I have good news about that. It's progressing well. We did have a bit of an additional delay, but we're now anticipating that the Cliff Palace Loop, that's been the kind of tricky spot up there, should be open for public use starting Sunday, July 24th. So that's the target. The contractors are working 7 days a week. They're doing evening shifts, night shifts to get concrete done. So it's speeding up, and we anticipate that the public will be able to access that part of the national park before the end of the month. So that also would mean that the tours of Cliff Palace and Balcony House would then be available for visitors to book using recreation.gov, beginning that same day, so July 24th, that Sunday. The way we have done the way recreation.gov has done our bookings in the past, they've previously done 14-day in advance bookings, but to hedge our bets, we've pushed that back to just 7 days ahead of time through the end of July. So beginning August 1st, we'll be back to the 14-day in advance tour bookings for rec.gov for the tours that are offered for Cliff Palace and Balcony House. So we don't have an exact date for when the Mesa Top Loop will then close for paving, because we've been phasing this, wanting to get the Cliff Palace Loop open first before we would close any other part of that road for the paving work. So probably early August is what we're saying for the closure of the Mesa Top Loop, but we won't do that until the Cliff Palace Loop is fully open. Then, as I've mentioned before, we'll progress to do the paving along on the Big Hill, and then we've got the roundabout project that will be the last part. That's going to go into fall, most certainly. But we're really happy to finally get some key areas of the park open on Sunday, July 24th. The only other update I wanted to point out is just that I've also been mentioning the 2 planning efforts that we have, the Spruce Treehouse Alcove Arch Stabilization Project and the Fire Management Plan. Those environmental assessments got a bit behind schedule for their public release, but we're anticipating that both of those will be released for their 30-day public review early August. So we'll make sure that you are made aware of that, and I'll be able to brief any and all of you on those at that time.
Okay.
Fire down south?
I'm sorry?
You have a fire down south on your property? Is that what I read?
Well, it's not on the park.
Okay.
We've just had a couple of individual lightning strike single tree fires on the park that we've been able to extinguish right away. So we've been lucky so far, and we're glad that we've gotten a bit of moisture up there so that our fire danger is down to moderate right now.
Good. Where's yours at? Derek, you guys have lifted all your restrictions, right?
Correct, yes, we've lifted ours, and similar, we've had actually quite a few single tree lightning strike type fires, but no management issues at all with them. And in fact, I guess since we're talking about this, in the event that we get a natural ignition in the right place at the right time, it's something that we would probably consider managing if there again it was the right time or under the right conditions. Because we have a lot of burn units out there that we've been prepping for the last 3 years because we haven't been able to burn. But we have lots of burn units out there that if we can take advantage of utilizing those features, with a natural ignition, that we would consider that. We had one about 3 weeks ago, but we hadn't lifted restrictions yet. It would probably have been a really good candidate because the rain started a few days afterwards, but they said, yeah, the rain's gonna come, but you never know until it's actually here, so we didn't wanna risk it and get ourselves into a bad situation. But with the rains that we've received since then, I think we have some opportunities.
All right, very good. Well, if we have nothing else, thank you guys, appreciate it.
Thank you.
Appreciate it.
And we will get back to you, Derek.
All right, sounds good.
All right, thank you. All right, now I'm gonna jump back to the top of our agenda, and vehicle maintenance, Shane. County operations.
All right, I don't have a lot since I was here last week getting those pickups. We got those pickups here. They'll be on the road here within the next week or week and a half for the road department, so that's good. finally getting a few new vehicles in the fleet, even though we're having to pay retail price for them at this point. We're just happy to get some new rubber on the ground, so. I either need to do a workshop time, we need to figure out pool funding so I can move forward with that. That it doesn't need to be a lot of money. I would assume $5,000 would carry that pool through the rest of the year, and then we can deal with funding beginning of the year to get it into the administration budget.
So why don't we put that on the next workshop, and you can send us that proposal, and then we can have something to view and discuss, which would be the 18th.
Okay.
So,
I'll have something together by then to
yeah,
kind of back my numbers anyway.
okay. So, we can do that on the 18th.
Okay.
And we can just do that in a workshop,
Perfect.
all right?
And then,
Because-
there's gonna be some room in the budget, with the F-150 still not coming, still no word on those, other than they're still pending, so, we won't be paying those leases, so we'll be able to buy a few more vehicles this year if I can find them. They come up so fast and go away so fast that, as you guys know, we've had to have special meetings and things like that to be able to get them, but, we could probably afford 3 more vehicles, so I need to look real close at what those would be. And there is definitely a need, I just need to, dissect everything and figure out.
Yeah, I think you can bring that forward to us on our planning meeting, bring all the ones that we're gonna get rid of, and bring everything, what the biggest need is, and what we're getting rid of.
We still have the one floating out there for the maintenance department, which I talked about a couple months ago. They still haven't been able to find me anything that fits the budget and the need, so we're still got that hanging out there, but, I definitely will have a better, with all the vehicles being moved around, making a pool, there's quite a few vehicles dropping out, and then we can move a few of those vehicles over to some different departments and, utilize them a little better. So, I can bring all that to the workshop.
Okay.
And, that would be, we're gonna have quite a few to sell. I'm working with Enterprise on their ability to be able to sell the vehicles for us, but, it's kind of a slow process right now, but I will get that in the rolls, and we'll figure out how to start getting some of these vehicles sold that we're swapping out.
Okay,
But that's about all I have.
all right, very good. Questions?
No, have none.
Thank you.
All right, thank you, Shane. All right, Dustin back there. Buildings and grounds maintenance. Morning.
Morning, Dustin.
We had our elevator inspection since the last time that I came in and seen you. We had 2 annuals and a 5-year. And then, we replaced the AC compressor for the clerk's office. And the generator for this building is hooked up to the building now with the automatic transfer switch. And then we're building that fence panel while it's complete, and, for the wash rack out at the fairgrounds. And tomorrow, we're gonna get the road base in there and compact it, and scheduled for late this week to pour concrete.
All right.
So hopefully we'll have that done before the fair, or most of it. So.
Good.
And other than that, it's been business as usual.
The gals over at the health department made mention that they had money for a generator. Have we done anything on that, or is Spratlin working on that?
Yeah,
Spratlin.
Okay.
He did get with me, and we're working on it. We have some information from when we were looking at it.
Previously.
So just need to update all that.
Okay, good. All right.
Thank you.
Thank
All
you.
right, thank you, Dustin. All right, Mr. McLean, since you're up here.
I really have nothing new that we haven't already discussed last time I was up here, other than I'm working on broadband stuff in my free time.
Okay.
That's pretty much about it.
All right, very good. Doug, GIS.
Jim, in Dropbox, in the GIS folder. Folder says today I have a little PDF to display.
Where's it at in here, in the GIS data?
Dropbox GIS.
Under GIS data?
BOCC today.
This one?
No. Go back.
Back more?
BOCC today.
Right, whoop.
7/12.
One more, there we go.
Okay, I got it now.
That's it. Like, James, is this on now? James is gonna join me up here, to talk about this. Just a couple of things, just trying to keep my head above the water since we don't have a full-time GIS specialist right now. Gonna keep up with things, a lot of plats and PID changes still coming from the assessor's office, and trying to get back around to some of that stuff that Eve is sending over. And also we did finally get the 2021 imagery that we purchased onto all of our web maps now. That'll pull up in all of the web maps that we use internally, and as well as the public web maps. That was a little bit of a process getting that data delivered and then also cached on the web mapping services. Jim had to give me a little more space on the server so that we could host that up, but that is now completed. So we're good with aerial imagery for quite a while. And then just to talk about, I don't know if anybody's briefed you on a meeting that we had. It was spearheaded by the state of Colorado CWCB, Colorado Water Conservation Board, joint project with FEMA. And what they're looking at doing is, I've talked a little bit in the past about this LiDAR data that was collected a few years ago. And what they're doing is taking that to the next stage, coming to the communities and asking areas where we believe that we need a more detailed floodplain study to happen. This is, I believe, at no cost to the county. They have limited funds to do this in their region. I think they're looking at Southwest Colorado the next couple of years. And they met with us on May 26th, met with us, representative of the town of Dolores, Gretchen Rank with the Mancos Conservation District, a CDOT representative, again FEMA. There's a City of Cortez rep, as well as Tom Stevenson with the Ute Mountain Ute Tribe, so that we could brainstorm on this a little bit. We're now going to respond with the areas that we looked at that would be a priority for us. Presenting this, looking for any comments as I run through this fairly quickly. We do have a little bit of time on this project. You know, we're not going to really see a result of it probably for well over a year, 2 years, by the time we come to the board and ask to adopt new floodplain maps in these floodplain panels. The reason why we chose these areas is because back in 2008 and 9, when we last did a detailed floodplain study, we had really good data for the Dolores River Valley. We had really good data for within the City of Cortez. They had their own 2-foot contours. And we had decent data within the town of Mancos. Those were the only detailed study areas because those were the only areas that we had good topography. Now with this LiDAR data, we have it county-wide. So just running through these areas that we're gonna respond to that are our priority areas. What we're seeing on this map, what the contractor AECom, who will be running these hydrology studies, they ran kind of a preliminary flood zone model. Without getting really into details as far as here's where the actual structures are, here's the size, here's the head. Without that detailed study, they ran a preliminary model, which I think we said this looks pretty good. This looks pretty accurate and pretty well delineated. And it's countywide, and it's really interesting to look at. We were going to focus on areas that did not have a detailed study, that also have a potential for development type activities. And the reason for that is because, you know, if we get development out of here, if we want to do certain activities, this could benefit us, because we might be looking at a commercial development, road infrastructure, what have you, and this would be beneficial for us to have these areas adopted officially into the floodplain map. So this area just east of Cortez out to the fairgrounds, I think we chose this because there is some infrastructure, obviously, potential, and some potential to extend roads and other sorts of developments out in that area. And as you can see, the orangish color, and then to a degree the blue colors are more like a wetland area. The green is what their rough floodplain analysis showed, and obviously it better delineates it in some areas, and it expands it a little bit in some other areas. What this data, and I'll show it in some later slides, what this data also shows is that it can actually pinpoint where you might have some bottlenecks as far as culverts and things like that we could look at for infrastructure development. Am I on the right track there, James? Okay. So this area in general, Totten South over essentially the southeast part of Cortez was priority number 1, and then the next page there, Jim, is the southwest part of Cortez. You know, again, the green areas are the areas that, when they ran it, might have some hydrology issues, because we've been talking a lot about development around the airport. This would lend into that study, and also the data before literally stopped right at the city limits. And so if you actually zoomed into this, you would see that it didn't analyze the Cortez Sanitation District facility down there as a detailed study area. And then also, I think James pointed out, he would like to see an additional study, and David Dowdy with the town of Dolores, they would like to see an additional study up the Dolores River Valley to further delineate things with the current conditions, just because this is obviously our most important floodplain area. This data is significantly better than any of the data we've had, this LIDAR data, and because there might be some development up to the Dolores River Valley, we thought we would take that up to generally the West Fork Stoner Ranch area, have them re-review that. And then, what is the last one? The last one we looked at is the town of Mancos, extending that out to those areas, primarily just to the southeast of Mancos along the business route and those parcels, because those really are not well covered in the current floodplain maps. So it came down to the towns, the 1 mile areas, the development areas of that. And then thirdly, we did brainstorm with everybody at the meeting on some other areas of issue that have flooded in the past. Of course, we have famous Dawson Lake here, Dawson Lake area, which I think that hasn't flooded. That flooded maybe 5, 6, 10 years ago or something, it significantly did, and it can with the right conditions. Our plan was, it doesn't really make sense to really add this to a floodplain. It's more of like a situational issue, and yet there is some development there. But what we're seeing with this preliminary data is when you zoom into some of the areas, it'll show where it will crest the road. And maybe that's something where we say, you know, point out some infrastructure problems, and use that as a tool to maybe go and identify areas where we might need to look at some infrastructure type of issues to mitigate those. Because if you can solve it with infrastructure, then it's not a floodplain, and you reduce the problem, and you move on with things. So further down the list there, we had a couple areas in Road G where that potentially could be an issue cresting the road. We know that happened in a kind of a flash flood here a couple years ago. Road G briefly shut down, and there are about 3 or 4 areas along Road G where that can happen, and this study essentially shows some of those areas that we might want to further look at. And then lastly, 491 South, there was also a similar issue a few years ago that we had some water crest the road for a while, and that's really what the tribal representative pointed out, is that they weren't seeing a lot of issues in the rest of the Humanity Reservation area, but 491 and some of those drainages can do significant things if the conditions are right. So that's all I have. That's where we're going to start moving forward with this project.
So, something that was brought up last night in the Dolores Town Board meeting, there was talking about floodplains, you know, just outside of Dolores and their area of influence, 3 miles basically up to the corner right there where the subdivision of Lightenberger's is. They were discussing, you know, how far do they extend their sanitary sewer and or their water so that they can basically control what's going on up there. And somebody mentioned, well, there's all kinds of development and it's just happening without anything. And I was like, whoa, no, wait a minute. That's not true. They, you know, there are floodplain permits that they have to abide by if obviously they're in the floodplain. And so anyway, I assured them that we are watching all of that area as that goes on, but this obviously would help them, Mancos, and everybody else around our area. But this is a 2-year project? I mean,
yeah,
it'll take that long.
2 years, and, you know, collect all this data, process it, come around, do all the community outreach. I don't know what they have to do at this point to further refine it, but probably more modeling and stuff like that to ratchet this down just a little tighter.
Yeah.
You know, I might explain too that one of our purposes for looking up the Dolores River, we've got pretty good data up there already. But one of the questions up there is whether or not we want to take a look at officially declaring a floodway up there. Now, a floodway would carry significantly more restrictions on it, but it's pretty clear what you have to do to develop within a floodway. It doesn't prohibit that development, but it gives you very clear guidelines on what you have to do to accomplish that. Right now, it's all AE, and we're supposed to be treating it as if it's all floodway, but we have some latitude and flexibility in it right now. So once we get to the point where we get a good understanding of what that floodway is going to look like and the kind of impacts it might have up the river, we can make a decision, have a discussion and make a decision on whether or not to actually request an official floodway or not. We may choose to just leave it AE as it is, which is just fine, but at least having the data will give us a good idea of what it's going to look like if we choose to go down that path.
Okay. All right.
Yeah, and I'll just, last I'll just say, you know, that previous data was from 2003 that it's based off of. I think this being much newer data, much more accurate data would lend itself in the future, and I think that's why why the Dolores River Valley is so important. And just as a side note, when we were reviewing some of this, the engineer looked at the Leitenberger property, and he saw the Don Leitenberger's house there, and he's like, oh, that must be a fluke that there's an island there and that house isn't in it. And we said, no, they actually built that house up out of the floodplain, and so it is important that the data and the floodway, matches the current conditions as much as possible, and this is our best opportunity to do that.
Okay. Yeah, that house is significantly higher.
A lot higher, yeah.
Yeah, that LiDAR data really pops that out. It's abundantly clear with that data.
Yeah.
One other thing I would mention is that countywide, what it looks like we're gonna get is probably more floodplain. That's what it really looks like. They've, expanded the study to include drainages they didn't look at before. So, we're gonna have more floodplain out there, when that new map hits us.
We just gotta have more water.
I'm sorry?
We gotta have more water to have a floodplain.
Yeah, maybe they're just being optimistic, I don't know.
But it also comes, a detailed study also comes with a base flood elevation for somebody to work with. So if a commercial development wants to come in, you know what you need to meet. You know exactly what you need to meet to get out of it.
Okay. Is that it?
Yep.
All right, thank you, guys. Okay, Leslie, patiently waiting over there. You can, yeah, it's still
not yet.
Tuesday. Welcome. You bring up good news.
Not too bad. I mean, definitely could be worse, right?
Okay, well, yeah.
Doesn't look too bad.
Could be worse.
Yeah.
So I just did a 21 versus 22 assessed value. Just kind of give you the lowdown. In 2020, our assessed value, actually I messed up on my numbers right there, I'm seeing. 21 assessed value was $592,047,530. And this year, with what we have so far, we're looking at $619,949,350. A little incident we got thrown in was House Bill 22-223, which contains all exempt mobile homes this year. So the state has decided to exempt all mobile homes from $1 to $28,000 in actual value. They would become exempt from paying property taxes. So that has to be retroactive back to January 1st of '22. So doing a quick, I just had to do a quick query in the system to kind of pull out those values, because we do not until next week have exact guidance on how we're gonna make this all work. But that gave me an assessed value of $1,049,980 is what we're gonna have to subtract out of our actual value right off the top to exempt those mobile homes. So that gives us
That's a value of $1 to 28,000?
$1,000.
Yeah.
So to be taxable, you have to be $28,001
Over.
over. Otherwise, they're all just exempt. They'll get a $0. They won't even get a tax bill, just be $0. They'll get no notices of value. It'll just, like, they're not there. And I don't know how long this is gonna last. But that is something the state's doing this year. And I will have guidance after next week to find out how we're gonna make this all work in our systems. So that's just right off the top, not to mention the assessed values that got changed, going this year and then going forward, the decrease in values again. Or the decrease in taxable rates again. So this year, you can see the difference between 21 and 22's assessed values. And then for Senate Bill 22-238, looking for tax year 23, they will also be going down again, which I'm sure you all are aware of, but pretty significant decreases in even the commercial residential or commercial rate too. And then it looks like probably, I haven't got state assessed in yet, but that's pretty close to what we have this year. Looking at about $287,000 on the plus to county general this year compared to last year.
And next year's when we take the hit.
No,
No, or is it 2024?
we basically took the hit this year because.
Yeah,
we
we've
were
already
able
had
to
our,
use
I mean,
the-
with assessed values going down next year.
Well,
so those values will be payable in '24,
Right.
but then they go for one more year after that, I believe. Let me look at this. So they're not to be back to what they were in 2021 until 2025, payable in '26.
Okay.
So we're gonna have 2 more decreases between now, 2 more years of decreases. So '26 is when we're gonna be back to what we were in '21. So it's gonna be a haul, but.
Yeah.
And
but
then,
that's not a negative point right now. It's not very much, but at least it didn't decrease another 1.3 million.
Correct. Yes, I mean, I feel pretty good about what's, where we're gonna be looking at. And then I just wanted to, just take a little minute to clear up some conversations that have been had over here in the past about some of the stuff the assessor's office is or is not doing. So January 1st to May 1st, the assessor's office brought in over $60 million in residential value. We noticed those in May, and since May, we've added all of our new construction on for '23. So I just wanted to take a minute to pat my people on the back and say, I think you guys are doing a great job with the stuff we have, we do get addressing and we do get help from Don's office a little on the septic permits, but other than that, it is wheels on the pavement is how we pretty much find 90% of our new construction out there. I was out last week 2 times, and the new construction I had flagged versus what I just picked up out on the road. I mean, I went out to find 3 houses and I picked up 7, is how fast it's happening right now. So with, like I said, the abilities that we have in our office, I think we're doing a really good job with what we have. And I just wanted to point that out and say kudos to my appraisers. But we did bring in over $15 million just the first part of the year that is going on this year's tax roll.
Are you fully staffed?
No.
That was my question.
Are you short still the?
I'm short an appraiser and I'm short a deputy assessor.
Any luck?
And I'm filling in the appraiser position right now, on top of everything else.
Okay.
But,
Do you get any back and forth with the GIS department? Do they help you out? Is those new?
they send us the addresses
Okay.
when someone applies for an addressing permit. The thing that's hard with some of those is when someone applies for an addressing permit, it could be very, very premature of them building a house. And, we flag it and we do go out, but it could be 2 to 3 years that we go out every year before anything actually happens. Because we don't have that, we're building, it's just, they've done everything on their property to be in
Right.
compliance, but they haven't actually started building, and sometimes they'll put a foundation in the ground and the foundation sits there for 4 or 5 years.
Right.
So it's just a matter of we have to go by that property every year, physically inspect it, because there's no building permits to let us know that anything's happening. So that's where we're at with that, but, I go back and forth about looking at a new appraiser, simply because seems to be history in our office. They give us about 2 years and then they go get their real estate license and take that money that we trained them on and go out into the private sector. It's hard. It's a lot of classes, it's a lot of training, it's a lot of time out of the office. But that seems to be a big issue for the assessor's office, and not just here, for all counties. But it's hard once you get someone trained and spend all the money on that and then they just leave you after 2 years. It's hard. So that's why I'm just filling in right now until we can figure out a better idea of how to make it all work. But
Okay.
I feel like we are doing a pretty good job.
All right. Any questions?
No.
All right.
Thank you very much.
Thank you, Leslie.
You guys have a good day.
Yep,
You do the
too.
same.
Landfill, Mel.
Sorry I missed last week, I was a little indisposed.
What?
I had COVID last week.
Oh, okay.
You got my budget up there?
Yeah,
Tim?
I do.
While he's getting that, anyway, so in the month of, my budget's for May, because I haven't got my June stuff yet. We sent out 7 semi-loads of cardboard in June, which will show up next month, in my budget. We changed the prices like you'd asked on the mattresses, and we added the medium-sized animal to our deal. I finished the last report for the grant on the trommel screen. That whole project is totally, completely done now with CDPHE. And the CDPHE has just sent me the paperwork to start on the new one. And as soon as I go through that, I get the signature signed, and we'll move forward with an RFP on the equipment for that. I also have our engineers starting the drawings for cell 5, so we can get our subgrade points before we dig too deep and have to fix that. Of course, I missed last week, but according to the crew, we've been extremely busy. The landfill's filling up a lot faster than everybody thinks, because we're doing so much business down there. It's like it's doubled since I've been there. So we're just gonna keep moving forward with what we're doing here. The old BOMAG, the injectors are out of it, so I had to order new injectors. That's gonna be about an $8,000 repair for that machine to get it back up and running. And on the budget, if you go to the last page, Jim.
All of the injectors are out?
Yeah, they're gone bad in that machine. So we had to order new. I've had 2 different mechanics check it, and both of them have come back and said the injectors are bad in that machine. It had a warped exhaust manifold. They fixed that. We thought that would help, but it didn't. They come back and they still getting the same codes, bad injectors. So that's a newer motor in that machine. That's the second motor in that machine, and it already has.
Yeah, it's pretty odd that all of your injectors are gone at one time. I mean, that's not typical.
Yeah, I understand, but I'm just going by what the mechanics are telling me on that. Financially, we're doing pretty good, a little better than I expected. If you looked at the last page there. Buying the new ball bag, I predicted would be about $445,000 in the red at the end of the year. And this is at the end of May, and we're at only 338, so we're doing pretty well on that. And that's about all I got, unless y'all have some questions.
No, the only question that I have, and I think you answered it last time, was you could still take approximately a third of that chip pile if we can ever figure out how to get it down there.
Yes,
Okay.
absolutely. We got a spot cleared out for it. We could use it.
Okay.
Especially with what's coming up with this grant.
Yeah.
Okay. Well, we're brainstorming about it. We just haven't come up with a solution yet.
Well, yeah.
But we're
anytime.
trying.
We've already got the spot ready. Just let us know, and we'll have equipment out there to start piling.
Okay.
Yep.
All right.
Anything else?
Nope. Sounds good, Mel. Thanks.
Good.
All right. Let's do the unfinished business of Region 9 letter before we go to executive session. Is that all right, Ian? Can I skip that?
Yeah, that's fine.
Okay.
We can do that. We may have something coming out of executive session for unfinished business, the fiber management agreement. But if you want to do the letter of support now, we can do that and then go into executive session and then resolve if we need to.
Yeah, let's go ahead and do that, and then we'll go into the executive session. So yesterday in our workshop, if you go ahead and bring that up, Jim, we had a presentation actually from our former county administrator, who is now working for Region 9 now, And this is basically being sent to the Colorado Broadband Office. And it's a letter of support in collaboration with the other municipalities around our region, City of Cortez, Empire Electric, and so on and so forth. Basically to establish a plan. I don't know if there's a map, but there was a map displayed yesterday of how we create the redundancy around the area. And Jim, I'll let you explain it. You might be able to explain it a little bit better than I've done, but to put together a plan for the funding that's out there now for redundancy around our region.
So, yeah, I mean, if you want me to just give a little summary of what we're planning. So, around the state, we're trying to build a redundant network around the state, which gives the ability to provide high-speed internet or broadband by the FCC's definition. And the goal being to serve every household in Colorado, and specifically rural. So there's some money coming down the pike in the next year or two, but in order to have access to that, we have to have a good, solid plan in place. And one thing we figured out, at least regionally, that we have a much better chance of getting our fair share in Montezuma County if we work as a region, rather than trying to everybody do it on their own. And so regionally, that's Archuleta, La Plata, San Miguel, Dolores, and Montezuma have been working for the past few months building these priority maps. And then we've been meeting with Empire Electric and some of the ISP providers to try to ascertain where this all fits together. And that's kind of the overall summary of what this is about.
Okay. So basically what we have in front of us today, gentlemen, we obviously can't make decisions on Monday, so we had the discussion and we have a letter prepared. So we just have to make a decision on whether we want to sign this letter of support or not.
I move we sign this letter of support for to the Colorado Broadband Office, showing our support for Montezuma County for the regional collaboration.
Second.
Okay, it's been moved and seconded to sign the letter of support sent to the Colorado Broadband Office for providing services to residents in Southwest Colorado. All those in favor?
Aye.
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 Oh, that's a nice pen.
Okay, and with that, we will now break into executive session. If you'll read the,
I move we go into executive session for a conference with the attorney for the purpose of receiving legal advice on specific legal questions under CRS Section 24-6-402, parentheses 4, parentheses B.
Second.
okay, it's been moved and seconded to go into executive session for a conference with the attorney for the purpose of receiving legal advice on specific legal questions under CRS Section 24-6-402, parentheses 4, parentheses B. All those in favor?
Aye.
Aye. executive session. All those in favor?
Aye.
Aye. Okay, under unfinished business, we have one more item that we have to address. Commissioner Copenafer.
I move we approve this fiber management contract between Montezuma County and 2210 Cortez LLC.
Second.
Okay, it's been moved and seconded to sign the fiber management contract between Montezuma County and 2210 Cortez LLC. All those in favor?
Aye.
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 I got one just like it.
You got one just like it.
Yeah.
See, we all have one just like it. Okay, James, just come on up. Don't sit down. Get comfortable. And we'll let you go ahead.
All right, afternoon, gentlemen.
Good afternoon.
First thing I wanted to go over is we've got two invitations from the BLM to participate as a cooperating agency. The first thing the BLM is taking a look at is they're taking a look at all 64 counties in the state, and what they're going to try to do is identify important big game migration corridors. And really, my take on this is that what we're really trying to do is be able to dovetail in with the state oil and gas rulings, because that's one of the things that they're looking at, of course, is the big game migration corridors. So they're planning to do a plan statewide. It should encompass about 8.3 million acres and about 27 million acres of federal mineral estate. And so, within Montezuma County, we have a significant amount of split estate, and that's what they're really talking about with that. Anyway, they've offered us an opportunity to participate in that planning process as a cooperating agency. And so I just need to kind of respond, let them know whether or not we want to participate or not on that one. And there's another one here, and this one has to do with the sage grouse. And, of course, we haven't got any populations that we're aware of in Montezuma County, and yet there's a fair amount of Montezuma County that they're identifying on the map as being unoccupied habitat. In fact, that whole northern section of it, it's quite a bit of Montezuma County. So with this one too, that might be something we want to consider participating as a cooperating agency on that. So just want to let you know about both of those situations. And then I can get with the BLM and let them know whether or not we want to participate. In my view, I think it's probably worth participating in this and making sure we stay engaged. I know there's been some discussion on whether or not you participate as a cooperating county and then you can't participate as under coordination. In my view, I don't think that's true. In my view, FLPMA already defines coordination as something that's going to happen. So I think that these cooperating agency is something on top of that and doesn't remove any of our, or any of the federal government's responsibility to coordinate with Montezuma County.
Correct. The cooperation is actually the bigger key.
Right.
Yep. So we have two to look at, one for the sage grouse and one for the
right. That's
game.
Correct. Yeah.
Questions?
No.
Jim, I've got a question, just not on this, but I think you were here when the Forest Service came in earlier and talked about the FERDA easements. Do you have a general feeling one way or the other on a FERDA easement and how you might look at that?
Well, I would say that the FERDA easement, I think Derek's right, it probably gets you about 99% of the way there. But on the other hand, depends on what it says out in each one of those FERDA easements. And so I talked to Derek on the way out the door there, and he wanted me to try to track down the latest version that we had. And I'm not sure I have a copy of it. It may be something John actually has.
Yeah, I haven't seen it. I don't know. It must have been quite a while ago because I'm not aware of anything getting sent over. I can look through our files, but yeah, a lot of it's going to be the terms.
My concern is the same as the commissioners, you know, I mean, if we don't own that road, then it's, you know, I feel like we've got a lot of responsibilities for something, and not, you know, and we don't hold the ownership of it either, so that's a concern
So,
for me. And then when we take it over without having it be up to snuff.
Yeah, that's
to
my
begin
question.
with,
Why would
that's a
we wanna
problem.
take something over that's, you know, why would you buy a used car that's all dented and beat up?
Right. Yeah. And actually, Ian asked the most relevant question, I thought, is why don't they just transfer it to us? I always wondered that. Well, that's the first time I've heard that they haven't got a mechanism for doing that.
I don't believe that.
I kinda don't
I was
either.
gonna,
I can tell you right now, that
think
is
it
not,
manufactures
I really do not believe that.
I was gonna,
I
Because
don't either.
when,
Take an act of Congress, but
well, I'm not positive about that either, Commissioner. They transfer things all the time.
yeah.
because they were trying to, at one time, we were gonna actually get this road back from, because at one time it was in Montezuma County's
That's
control.
right, it was a state highway even,
Okay,
yeah.
yes,
Yeah.
it was basically a state highway. Well, then it transferred back to them,
Yeah.
basically because Montezuma County didn't want to maintain it anymore.
Right,
Because we don't, as far as resources up there, it's taxes and stuff, we get nothing back.
Right.
So basically, we're putting out, the people in Montezuma County was financing an access for somebody, for another county.
right.
Well, that's why it got dropped before, but they, and I can't remember that, the superintendent that was with the Forest Service here at that time, we were actually on track to get that transferred back to us. He was gonna get it transferred back to, and then he got moved out of here.
Right, yep. Steve Beverland, was that?
Yes, Steve.
Right.
Steve
Well,
was the one.
and, you know, and the other piece of the whole equation is, this idea that it's not an RS-2477 road because there was a realignment back in the 40s. That doesn't necessarily hold weight either. I mean, they're kind of hanging their hat on that idea, but I'm not convinced that we couldn't get an RS-2477 right where it sits now. I mean, there's case law that talks about roads realigning, and that's, I don't know exactly how far that realignment is, but, I mean, there is at least a potential for an RS-2477 claim even along that disputed section, I think.
Right. And so we pushed that pretty hard, you know, up until we hit the problem with that realignment.
Yeah.
So right now, we just haven't resolved the issue of the realignment. Otherwise, I think we'd be our road now.
And that's a little bit of a difficult thing too, because I mean, the Forest Service is saying, well, because the road realigned, we can't agree to an RS-2477. Well, they still could conceivably agree. I mean, I don't think that the realignment in and of itself would preclude an RS-2477 claim. I don't know. You know, I think it's at least a question.
Certainly.
So,
It's still a road.
yeah.
And
Yep.
realigned or not, it's still a road.
Exactly. Exactly.
Okay. Anything else?
So,
We just
yeah,
need
just let the
approval.
commissioners know, I've just been, you know, kind of, this week I'll be attending a field trip tomorrow with the Dwarf Working Group. And we're working on that CFLRP charter and everything. I think I explained that to you last week. I think I'll probably go ahead and take one of the positions on that working group. And, you know, just kind of keep trying to push forward with that. You know, this is going to be an ongoing effort with it, and we'll just need to stay engaged with that. And then I guess the other thing I'm doing this week is really just trying to finalize a lot of the reporting. We've got quarterly reporting due on a lot of these grants that we've got. In particular, the IHOP grant, and there's some data we're going to have to track down on that. But anyway, that'll probably consume the rest of the week here. But that concludes my report.
All right. Thank
Thank
you.
you.
All right, with that, gentlemen, we are,
I believe I have my report too.
Oh.
We skipped over it. It's brief.
kind of skipping over everybody.
Yeah.
So, what am I paying for?
Our report, I have no report. Okay.
Go ahead.
Attended an NCA meeting last week. We've got another one set for today. I think that the goal of the NCA work group and the goal of Senator Bennett's office is to get that legislation introduced by the end of this week. The one thing that we're still missing is the final map. I think we're supposed to talk about that today at 2. I still haven't seen it come through. So once that comes through, that's kind of the final missing piece. I think that the draft legislation is done, and so we're ready to move forward with that. The only other thing new in the last week, we did receive notice of a potential claim sometime back on a death at the jail. It's been several months now. It's been about a year now since that happened. I was contacted by the attorney that's representing the deceased individual's estate, and that attorney was interested in having Montezuma County sign a tolling agreement, in essence, extending the statute of limitations to 2 years for any potential claim. For a lot of the claims they can bring, it is a 2-year statute of limitations. There's a possibility that there's a few claims that do have a 1-year statute of limitations that would expire here towards the middle of July. Initially, it was framed as, we don't think that the sheriff's office is liable. This is a way to avoid an unnecessary lawsuit if you toll this agreement. My take is I don't think that we should sign any sort of tolling agreement. Those statute of limitations exist for a reason. If you don't have a legitimate lawsuit at a year, don't file the lawsuit. That's where we are ethically as attorneys. If you don't have a claim, you don't file the claim. You don't say, oh, I don't want to file an unnecessary claim, so why don't you toll it for a year so I can do some more investigation and figure out if I've got something.
Yeah.
You had a year.
Why would we want to do that?
I don't see any advantage to it. It has been turned over to our insurance company attorneys as well. I communicated with them earlier this week and basically communicated that I really don't think that we had a big interest in signing any kind of tolling agreement. But I wanted to put that on your radar. I have another phone call this afternoon with the insurance company's attorney just to discuss this further. But just wanted to kind of put it out there so you guys are aware that this is going on. Again, for most of the claims, it's a 2-year statute of limitations. As I looked at potential claims that could be filed, I'm not even sure that there are claims with a 1-year statute of limitations that she could file. But you know what? To the extent a 1-year statute of limitations applies, my advice is keep that on the table. I don't think it's ever smart to take those kinds of things off the table in these sort of circumstances. And so just wanted to give you guys an update on that. And that concludes my report.
All right. Do you have anything, Commissioner?
I don't have much to report other than I did call Southwest about me taking Don's place until we find an appointment and got that set up to go.
So, in regards to that, it's kind of interesting when you look at the statutes, the way Southwest is set up, when our appointee gets a vote. It's appointee for, I think, a 2-year term is my recollection, or is it a 4-year term? I'd have to look back at the statute. Commissioner, if you're planning on serving even in a temporary capacity, I would recommend that we make a motion and temporarily appoint Commissioner Copenhaver to that board, just so there's no discrepancy, so you'll get a vote and you can participate fully until we find somebody else. I think that that's the cleanest way to do it, just so we're conforming with the statute and we actually have somebody appointed rather than having some kind of discrepancy.
If that's what you guys want to do.
Yeah, I'd make a motion, we appoint Gerald temporarily to the Colorado Water Conservation Board.
No,
And, Southwest.
Southwest.
I don't want to be
I
on
got too many.
Colorado.
Come on now.
Southwest Board, and I'll
Southwest
second it.
Board, yeah.
So it's been moved and seconded to appoint Commissioner Copenhaver temporarily until we find a replacement to the Board of Southwest for our water representative. All those in favor?
Aye.
Aye. Okay. Till we find a replacement.
Okay.
You're our voting member.
Southwest Board of Conservation.
All right. With that, I don't have anything.
Okay. Motion to adjourn.
Second.
Moved and seconded to adjourn this July 12th meeting, 2022. All those in favor?
Aye.
Aye.